May I please? With the consent method. Item number 38. May I pray for an adjournment of 2 weeks?
Reason?
My lord, I was asked to prepare a list of dates I have prepared. I'm standing in as a legal aid counsel. I want to have it verified from the client.
Okay. On the prayer for the prayer of the learned legal aid counsel for the petitioner, may trust and adjourn for 2 weeks. List accordingly.
Sorry.
Hmm?
Sir, our item number 8.
Yes. What is this issue?
Is
You want an adjournment?
adjourn.
Okay. On the prayer of the learned counsel for the petitioner, may trust and adjourn and be listed after view. View.
Daily item. Roll.
Withdraw.
With regard.
What liberty? Your grievance is that you arbitrator is huh? Arbitrator has already been appointed, isn't it? Arbitrator appointed. Yes, state. So we cannot issue a direction to complete the arbitration within a specific time. Mr. A. Rahman, learned counsel for the petitioner, prays that he may be allowed to withdraw this petition with a liberty to file a fresh petition. Mr. C. Mr. C. Borua, learned standing counsel, NHAI. NHA has not objected to such prayer. Accordingly, yes.
Item 31. With the consent of the third side, my lord, I break for my lord 7 days time to file a affidavit.
Okay.
Item 31.
Mr. B. Gogoi, this matter stands adjourned for 3 weeks on the prayer of Mr. B. Gogoi, learned standing counsel, finance and taxation department, to enable him to file affidavit.
But on 24th of April, the senior counsel is paid. 24th of April.
Please speak on 24th of April.
I'm obliged.
For listing on 5th April for admission.
You make this mention on 1st of April. Okay.
I beg to
Make a mention on 1st week of April. Okay.
Please allow. Personally, it must be able to take up the.
Have you taken, you are for a petitioner? You have taken consent from the other side?
Other side is the PNRD department.
So is no consent is required.
I was informed this morning.
You informed this or you have been
I
informed?
was being informed this.
Okay, wait for something. We'll adjourn it, repeat the prayer when matter is.
It may please your lordship. Your lordship, this matter is for listing your lordship WPC. Your lordship, if the matter may be listed on 27th or 28th, there's an urgency, your lordship. What happens is, your lordship, the commissioner had already sanctioned the proposal, your lordship. This is a tax matter, your lordship. The winding up had taken place of the company, as well as there is a proposal for this. Your lordship, before the end of March, if our company does not submit the thing, your lordship, then it becomes a problem for us. If it is listed in April, at least for the
Already notice issued.
no, your lordship.
It's press matter.
Indeed, your
Press matter.
lordship.
Permitted.
Much obliged.
It's item number 35.
Yes.
I have keep the deed after your lordship order.
Okay. You are MS Krish.
No,
I'm on
petitioner in person,
MSA Saikia, petitioner in person, has submitted that the grievance raised in the petition has been redressed accordingly. he submits that this petition may be closed being in practice. Prayer stands allowed. Mother to Mr. K. Kogoi, landed the CGSC,
Sure.
has not objected to such prayer. Yes, Mr. Nath,
Look,
just tell us what is your instruction
well, I have
and
received,
be amicus, not
correct. Well, I have received the instruction, just and basic, not the entire thing, just to correct. There is no eviction, well, eviction.
no eviction is there.
There
There is no contempt.
Eviction was done in the month of September 22, much before the
Huh.
Honorable Court passed the order.
Huh.
But now, the particular land has been,
Whether they are having ingress and egress.
yes, roads
That
are,
is available.
roads are there. Kindly, there are 6, 7, 8. Are they enough? 6, 7, 8, 6, 7, 9. These are.
These are whether they are patta holders, they should be evicted. That is a subject matter.
It-
What
it
is our concern is there is a specific order, they should not be evicted. Okay, you have evicted, okay, fine. But what their allegation is that after that we'll examine the contempt, no doubt on that.
Lot,
Our anxiety is the way the photograph childrens are being,
so
that you should ensure.
my specific instruction is that
With that instruction, I want to know.
9.
There are nine.
At several points,
That you file affidavit, these are the issues.
at several points, roads have been kept open for ingress and outgress of those still residing inside the scheduled land.
Mm.
That is, Lordship may record this, and those points are there. From that they can go.
Okay,
That they can.
hard.
And my lord, they are not still after the eviction was done in the month of September 22. But in the meantime, the order came and they were still there and they are not disturbed.
Okay.
And this position.
Okay, we understand. That's why we wanted your request.
Lord.
We'll say that in this Kuzedo, hard,
Yes. On
hard
the basis of instruction.
notice, normal notice, contempt. This court, looking at the seriousness of allegation that the petitioners, looking into the seriousness of allegation to the effect that the barbed fences were raised in the boundary of the land in questions, and there are no ingress and outgress for the petitioners, this court under its order dated 19/3/2024 requested Mr. D. Nath, learned senior government advocate to obtain instruction in this regard. Mr. Nath has obtained such instruction from the District Commissioner Sonitpur, which reflects that which is the relevant portion is quoted here in below.
Correct.
Huh?
Correct.
Paragraph 9. Okay, paragraph 9. Good stuff. In view of the aforesaid position, this court expects that the deputy commissioner will ensure that this petitioner are having or ingress and outgress. Okay. We may not please the in view of that. No further order need be passed. No further order needs be passed except issuance of notice. We have issued notice.
Lord,
That's all, and we have recorded that.
I have one subject. Lord, there are 300 facts.
Mm.
Most of them are affected.
Ah.
They are left out. We are not disturbing, but ultimately the place is required. 1,000 acres of land is required for a park.
Ah.
Solar
So therefore,
power-
you file an affidavit.
That
We will
so-
decide that.
that solar power plant area
Mm.
that has been now the remaining families, they cannot claim that the entire area belongs to us.
No, therefore,
That they cannot do.
they cannot. So
they-
therefore, what I suggest is,
So the project has
you
to,
file an affidavit in the writ petition so that we can dispose of the writ.
yes, that will,
Okay.
and the project activities in the other part of the land, that is going on, that petitioner.
That
cannot
we are
claim
not
it.
commenting in the contempt
No,
right now.
Yes, yes.
We are not
In
commenting.
the main case, we will file it.
I'm
And the
grateful,
main
my
case will go in the Mr. A. Sharma, Learned Counsel, State
You
Counsel.
may record my name in the,
Okay.
I'll, in fact, we are both there.
Okay, Adina Learned,
Yes.
Senior Government Advocate. Further submits that the state will be
Filing a.
in a position to file affidavit within a
In the-
period of 2 weeks from
Yes.
today accordingly. Let this matter be listed after 3 weeks.
Lot.
In the
okay.
meantime, parties may exchange their feelings. Interim order passed earlier. That's all.
I'm grateful.
You take steps in the contempt. Or Mr. Nat, do you have an instruction to appear for the Deputy Commissioner? We are
No.
not issuing notice to others. Who are the others? Janendra Tripathi.
Yes, Lord.
Why everywhere he is being made a party?
Principal secretary of the department. He has no knowledge at all what is going on.
While doing that, while these activities were going on fetching, then those people who were there,
Okay,
the
a
officers
notice at this stage to the respondent number 2.
2 and lot 2.
Two.
2, 3, and 4.
2, 3, 4 will act under 2. Let us see.
2.
2 was also acting after someone. That is why we have to make the
No, madam, contempt.
I leave it to my thought.
No,
I
no,
think
this is let the notice be issued to respondent number 2 and 4, not 3. 2 and 4.
I'm grateful.
2 and 4. Can you accept?
Let it go.
Okay, let 2 and
Contempt. Eventually, they may give me.
4.
Let the notice. Oh, problem. Yeah, please.
Yes, Mr. Sohan.
My lord, the,
Where is the order?
yes, my lord, the page 15, my
Yes, 15.
Yes.
Direction to whom?
lord, the relevant portion is my lord 17.
District Magistrate Dorong.
Yes.
Respondent now here, contempt number
Only one.
only 1. And according to you, it was not been done till
Yes.
today. And notices is served, these are the notices.
Yes.
Notice. Take steps by a week, 7 days. Returnable 6 weeks.
Apply.
Okay. Where is the order?
Page number 7, Your Lord.
Page number
Page number 7, relevant portion at page 9, my
is 9.
in the last paragraph.
Ex gratia.
Yes.
Who will decide?
My lord, respondent number 3 in the writ petition, my lord, in the contempt petition, respondent number 2 will sanction the sanctioning authority and will verify.
No. Who will? Somebody will have to examine. Who will
Yes,
examine?
respondent number 2, my lord, in the contempt petition.
Respondent number 2 will examine.
Yes,
Examination has also not been done.
no.
Where is your service upon respondent number 2?
My lord, at page 11, my lord. And also,
Deputy Commissioner Amingo Kamru. Notice to who, respondent number?
respondent number in the contempt petition 2, my
Deputy Commissioner is respondent number 2.
lord.
Here.
Yes.
Notice to respondent number 2 only. Let's will see who will sanction. Let first the Deputy Commissioner.
Number 5.
4 and 5.
And 6 in the On the petition 6, my lord,
Mm.
the respondent authorities are directed, my lord. That's why the two countermarks has been given in the item number 6, my lord. That is, my lord, 9.
We are giving a now at respondent number 2 for the time being, deputy commissioner, and then we'll see 2. Same.
In item number 5 and 6, my lord, my name may be reflected.
Okay, name of, name of the, you do it in the registry. Let us not, this will come together. It is high level. Hey, Mary, my name is not reflected. This is not a forum. Law is well settled.
Fundamental right, my lord, fair investigation is a part of the right. That's been violated. Order is only register a case for that.
You know, Mr. Doctor, the law. Even the after what is that earlier judgment?
Sakiri,
After Sakiri re-verified recently says that even High Court, Honorable Apex Court has said, don't entertain. Now the High Court will be an adjudicating authority of it. Because your rights, you are having a remedy. That even the investigation can be monitored by the magistrate.
Yes.
Then why should we entertain?
This is a case where there was serious land transfer involving high officials.
So we
That is
understand.
part of the reason why they are not
But your case is not for an investigation, not for investigation on monitoring by this court, saying that these are influential parties. This is not your case. Had that been your case, that would have been a different. This is the case where you say that investigation. Go to the magistrate. Okay. Mr. Dr. Learned Counsel for the petitioner submits that if you, in view of the determination made by the Honorable Apex Court in the case of Sakiri Vasu versus State of Uttar Pradesh and others reported in 2008 SCC 409, he may be allowed to withdraw this present petition and approach appropriate forum. Prayer is allowed. Accordingly, this petition stands closed on withdrawal with a liberty at
obliged.
now at this stage. Yes, Mr. Vishwas, tell us.
My lord, firstly, my lord, the entire no confidence motion is misconceived and misplaced. They are invoking the jurisdiction of the deputy commissioner.
Hmm.
They have not issued a single requisition to the chairman. Then the vice chairman, the law is settled, my lord. The requisition has to be made to the chairman. If the chairman fails within 20 days to call a special meeting, then only they can, either the vice chairman or the people who have sanctioned, who have sent the requisition. They have to send it. Now, here, my lord, deputy commissioner is alien to municipal administration. His jurisdiction has been invoked. This is one. Second, my lord, be that as it may, even the vice chairman called a no confidence motion that failed, my lord. And they have,
No, if first point is clear, then second point is that meeting is have no validity.
then the vice chairman called a meeting.
Hmm.
Meeting has failed. They file FIR against unknown person. In writ petition, they come up with all these, my lord, in new facts, my lord.
Now you are representing whom?
I am representing the present chairman and some other ward commissioner.
Okay, Mr. We'll issue a notice for this stage. We cannot say that hold a meeting.
Notice even issued.
No, notice is issued in the second writ petition, not in the first writ petition.
I have not
No,
received copy
no.
of.
Give a
Notice is-
copy to
no,
him.
Notice,
No, please, Mr. Sharma, tell us what kind of order can we pass?
now, my lord, what he is saying,
Hmm.
just I want to counter that.
No, that counter is, will that give any result in shape of an order today?
Your lordship is issuing
A notice. He
notice.
will accept. Let us see. Already there is a direction for record. We'll see.
I'll
Now
file an
his
affidavit.
whole case is that where is the deputy commissioner? If that be so, we'll see that.
No, he is saying that the deputy commissioner has no element of power under.
And
My
that
lord,
yes.
There is wrong submission.
No, we are not recording anything. We'll
How
just
can
saying
we
not
say?
issue
Who is
note.
the controlling authority under 296, 297?
Okay.
Yes.
Item
Record has been called. my lord.
number. Item number. Okay. Heard Mr. R.P.
Your
Sharma,
lordship
Learned
may go through the record file and
Senior Counsel, assisted by Deka
$3.
Huh? A? D. Dole, Learned Counsel for the petition. Agree by a proceeding and resolution dated 5/1/2024 relating to a no confidence motion against respondent number 7.
My lord, in
Okay.
9, my lord, I'm not a caveator,
Okay.
so a notice has to come to. I'm in 10.
So,
I'm point caveat.
relating to no confidence motion against respondent number 7. The present petition is relating to a no confidence motion. It is the case of the petitioner that though notice of no confidence motion was issued by the petitioner, however, a fabricated resolution was taken showing that the no confidence motion has failed. No confidence motion has failed. Issue notice returnable on as soon as possible. We understand, but Bihu is there.
After
Many
Bihu.
after Bihu, not after. Returnable on, give a date. Yes, Mr. Biswas, as per your-
Record has been called.
Uh,
If a lordship examines the record, then this petition may become infructuous.
No, we understand. Therefore,
Yes.
let it be
Re-
here
re-
for the time being. We will have it after.
Because my no confidence motion, otherwise, your lordship knows this scenario. They will be influenced and forced because already another thing
That is the
already very
that
serious
is the
allegation in the
good and bad of democracy. We cannot decide certain things.
No, your
That is the
lordship
mandate
cannot
of the
decide.
electorate.
What
my lord.
I want simply to hold the no confidence motion. Your lordship can direct within 15 days
So-
at the to meeting.
That
Yeah.
will direct, provided it is a legal. Suppose first for that we'll have to say that this not confidence motion was bad.
Bad.
Then the question will come.
That-
Okay, if it
that
is
would
bad, you
explode-
are at liberty.
That will be exposed by the
So
record.
that needs a deliberation.
Yes.
That what we are proposing is immediately
What
after Bihu.
What I am submitting very shortly is that if a lordship examines the record,
Hmm.
the record has come. If that is
Do you propose to us to hear this method today?
not the new one, the old one, the 168.
Interconnected. And if the old one has to go.
Then what is the meaning of filing this writ petition?
Because my lord, because they are
That is the issue, and you will have to give him a chance, Mr.
no, we will give
Returnable and give a date after Bihu. 29th of April.
can you repeat short term?
No, not possible, Mr.
Today is 23.
We know everybody in the urgency. There are 40,
Because it is a matter.
40 motions in the board,
Yes,
64 matters in the list.
One thing.
By 4:15, we'll have to finish.
My lord,
In between, I need not tell all this.
Yes,
In
but
between, there
one
are
thing
only
I
2
submit, my
or
lord.
2 working days before Bihu.
My lord, on 5th of January 2024, this resolution was passed and they filed the writ petition in the month of Feb end of March.
because there are
And they are
subsequent
showing
provisions. My
urgency.
Okay,
subsequent
let us
provisions.
not
How
go.
far that is legal?
Mr. Sharma, please, let us
If
not
your
go to
lordship
that
did
debate.
their
Please,
legitimate, they
please,
admit that is
please, returnable on 29th of 2022. Who accepts for whom? 1 to 5, Mr. Biswas,
I'll accept.
you accept, no?
I'll accept.
Mr. Biswas accept notice on behalf of respondent number
7 to 10.
Extra copy.
extra copies,
So then they will-
extra copies.
I'm
Extra
deeply-
copies within a week.
I'm deeply.
Record has come.
record is-
It is submitted by MSS Sharma. That record has already been received. Duita common order pass karbe board na. Receive the record be retained till the next day. 1 to 5. Yes.
This will be taken after some time. The case purchase is.
We have passed some orders in Mr. Bothakur's case.
I understand. Lord.
So we'll
That's the different. This is the different case. There's a different identity. But it can be.
we wanted that to know some when matter is fixed.
27.
So we'll take it to 27.
No,
Any urgency?
Yes, Lord. The case was in legs.
No, tell me what is that urgency? They are supposed to do it by 31st of March.
Even 31st of March, they have extended. They have the time to up to 31st of March. But a scheme law.
31st of March.
Okay.
And what is the urgency?
Lordship, that's what Lordship, on 27 Lordship.
Are you not aware what is the urgency? Do you need to call Mr. Ken Choudhury to answer this? We'll adjourn it, but we are asking you
Not
what,
adjourned, after some time.
what is the urgency? What is the matter about? Tell us. You have not read the brief.
No, I have read the brief.
Then any bar in telling the facts?
Oh, no.
Then that is what I am asking.
Lordship, in this case, this actually, this if you letter
Mm.
is cannot be passed by a direct
Mm.
because of the guide. The guideline has been given in the year 2020.
Mm.
After that,
Okay, okay. That same order is under challenge. That as is where basis.
No, yes, Lordship, that is with respect to in that petition, the claim is Lordship that they will they
Okay,
want
we understand that he is not having a power. He has already passed. If we take this matter on 27th, what action they will take till 27th?
nothing will happen, Lord.
Be reasonable. We
After
are in a
31st
board
days
of
time,
60,
Lordship.
64 items. May not be possible to give
But-
time being.
But the idea is
Please this matter on 20, 27 along with
we'll provide
give them 1641 of 2024. In as much as it is stated by Mr. K. Gogoi, learned counsel, that in the aforesaid matter, this court has already sought for instruction. In the motion column.
regarding land acquisition by the additional land acquisition by the railway authorities Lordship on 2018.
Heard Mr. Thor, learned counsel for the petition. It is the case of according to him, his land is taken, but while taking, you have taken extra. We'll have a report from the circle officer.
Yes, well,
If that be so, he is in. If not, then he is out.
otherwise, मतलब there is a report in मतलब order in
65.
65 मतलब
हाँ.
there is मतलब earlier 2 occasion he got the compensation मतलब but subsequently मतलब another one kotha 6 land, but regarding that मतलब no acquisition record is
Ac-
available.
According to him, that okay, this is the land you have taken, paid money, I am happy. But
Something
under
like-
your position, more lands are there.
Yes.
Either pay me or give it
Yes,
to back,
yes,
give it back. That is your case.
That is-
Heard Mr. Thor, learned counsel for the petitioner, and Mr. Pinto, learned counsel, learned CGSC.
this is for response of 120 मतलब.
Response number 123.
Five.
5,
No, so
5, 6, and Mr. Pinto.
So-
What else?
so-
Just give any note. The grievance of the petitioner is that his patta land has been occupied by the respondent railways without any process of land acquisition, in as much as earlier his land were acquired and payment were made. Full stop. Mr. Payment were made. Full stop. Issue notice, except the on the next day fix the who is the circle officer?
that will be response number 7.
6.
7.
7. You are for a 7? Respondent number 7 may file an affidavit after appeal verification whether may file an affidavit whether the land stated to be in occupation of the railways is actually in occupation and has been in occupation without any due process of land acquisition. That they can be, and the railway also respond to such allegation in the meantime. Stay extra copies.
It allocates exemplary clause.
That will, because we'll keep a circle officer busy in this. That is for sure. Yes. Already demolished.
Demolition 2000, November 2020.
What to do now? Will issue a notice?
They want that it should be restored.
We'll see. Heard R. Sharma, learned counsel for the petitioner, and Mr. Bora, S. Bora for the
No, 1 and
respondent number 1 and 2.
one,
Who
no,
are
up to
for
4,
whom?
sir. 1 to
এই তুমি যদি এখন স্লিপ এখন বনাবা বনাই পেলাই দি থবা এভরিবডি উইল রাইট এন্ড ওকে এখন বনাই বান্ডল করে
I am paying for all the respondents.
অল দ্য রেসপন্ড
No, all not. There are performer respondents on 5 to
Actually, they are the landowners.
ওকে লেন ওকে the grievance of the petition
Continue.
notice to those generally the grievance of the petitioner is that is against certain demolition that has been executed by the respondent municipal corporation or GMD, respondent municipal corporation, and it is the case of the petitioner that such demolition was illegal and therefore they are entitled for a direction of restoration. Issue notice, returnable. 5 days extra copies within a week.
Problem.
Notice to the performer respondents to registered post with effect. Huh? What is the issue? Tell us.
The non-profit item of it, 40 activity. To take appropriate action against that.
Now, what kind of writ will we issue? To a executive magistrate exercising power under 145. According to you, he has not executed it or what? Hmm? Hard. You are Mr. P.P. Pupon, learned counsel for the petition. The grievance of the petitioner is inaction of the officer in charge, Gorsuk Police Station. It is the case of the petitioner that the executive magistrate, in exercise of its power under section 145, section 145 CRPC, issued a direction. What direction? Where is the direction? Huh?
With 98, 38.
Issued a direction. Why don't you go to civil court? 98.
98.
In exercise of under section 145, direct CRPC directed the officer in charge Gorsuk Police Station to cause an inquiry into the matter and submit a report at the earliest. Such direction was also earlier issued on 2/7/2022 and 26/9/2023 by an order dated 26/12/2023. Yeah. The grievance of the petitioner is that the magistrate is grievance of the petitioner is that the officers in charge is ignoring such order of the magistrate, and there is no power and basis in the section 145 for execution of the magistrate order. This matter needs examination. Accordingly, issue a notice returnable. Needs examination. Full stop. MSS notice petition returnable on given date. MS Sharma, learned counsel, shall learned counsel representing the state shall obtain an instruction from the Commissioner of Police, Kamrup, whether the allegations made that the officer in charge of a police station is sitting over the direction of an executive magistrate is correct, and if so, the reason thereof.
But what is grievance is against the police not acting. There is a procedure inbuilt in the code. You can approach the jurisdictional magistrate.
Jurisdictional magistrate means where?
So there in America, that
No.
inaction 163 is there.
But this is not a case of affair. This is a case, see, there is a situation, this is not the only case. We are getting cases like this. Police has reached to such a position nowadays, we are not in a police state.
Hello.
So if, okay, there may be some procedure, but we want to look into. Executive magistrate exercising power under 145 is writing communications after communication, saying, please give a report. Is it his not responsibility? And allegation is serious and the person is been thrown out of his property. And your state policy, as we have learned, that it's a zero tolerance against this land mafia. So we want to know. So let the Commissioner of Police, we may take it as a suo motu, so means we'll extend the scope of this writ petition. Serious allegation. You have the instruction.
I will.
No. Very nalage. Notice nalage. Give extra copies. We are fixing it now. Notice itself on 28. What is the urgency? What is the urgency?
The urgency is, my lord.
We have fixed similar method on 27.
No.
We'll take a call on that. We want to have the view whether you can take over an NGO or in that manner, whether he is having jurisdiction or not. That is another issue. Additional issue will take into.
No, correct. My lord, can I put a lot to sign permission? I want to read one paragraph. Very important. If after reading that paragraph, Lordship says, I have no case, I'll go.
No, we have a prima facie view that you have a case.
Yes.
Therefore, we want to have them, give them a chance and fix it on 27.
So, my lord, one point was,
That we will urge on that day.
my lord, may I pray for one? Observation.
Yes.
Any action taken will be subject to the outcome. Person to the impunity.
Any action taken already.
No, not taken. If taken in the meantime, that is subject to the
Mr. Gogoi, don't take any action because we are under examination and your date is 31st. Our concern is, that's why we have fixed it in the motion stage itself. Our concern is that they say that you cannot do like this. These are rented premises. They have accumulated some properties. According to them, I am not. Okay, fine. But whatsoever, you suppose you have allowed them to do it. Okay, you have allowed to do it. Say by mistake, assuming for a moment that it should be one we have given. Now we have taken a policy decision. Will take over.
2 is not the issue.
But what will that permit a state to do in a manner like this? Private parties are not being allowed to do that under Tenancy Act. That is our concern. That's why, since it is 331st, we have asked you, what is your policy and under why this action is sought to be taken? That will take up on 27. That's why.
Till then, they will not precipitate the matter.
They will definitely not. Let them do. We'll see before 31st. That's why I fixed on 27.
Pilot. Skip.
Yes. Polta.
Issue is that on revenue application file is pending in revenue.
Okay. According to you, what is your case? Tell me.
This petitioner is hard forfeited with the
See, where is that any notification that this should be taken up by DB? Tell us.
no, that notification is not there, but when I personally appeared in the court, Court issue.
Okay, we'll take up this matter after some time. We want a senior government advocate.
Yeah.
And then we'll like to have the advocate general here.
Sure.
Okay, this is not for this case.
Yeah.
This is a very serious issue. Board of Revenue is without members and chairman is not there.
Perhaps, one member was there, but my matter is for a division bench, so that it did not take up on last occasion.
So there is no division bench.
No division, or that day also.
No, not that. That day is not an issue.
I
Is
entered in office. I entered the office.
No, is division bench available?
No, Lord.
In Board of Revenue, division bench is not available according to you.
Yes. In my case, Lordship, I entered the office whether division bench is appointed or not. They have informed me that they have no idea when the division bench will be appointed. So that's why I have preferred. I got the point, Lord. Lordship is asking me whether division bench is there in,
Available or not?
not available right now.
There is no division bench available. So if no division bench is available, it is not only your case.
Yes.
Then we will like to know how many division bench matter are pending in the Board of Revenue and how government is trying to deal with this matter. Can this court be converted into a division bench? That is what our query. Call Mr. Nath first, then if necessary, we'll call Advocate General. Yes, Mr. Bhattacharya.
Lordship, this relates to removal of the petitioner, your lordship.
What is this interim council?
This interim council
What happened to the earlier writ petition?
just pending, your lordship.
What was the subject matter there?
There, your lordship, I was removed from your lordship post of chairman.
Now you have been removed from
From
member.
the member. Now, your lordship, this PP Singhal judgment, your lordship, on this point is very clear, your lordship. They have the power, but they cannot be used arbitrarily whom to tell them.
So where is the removal order?
Page 43. Your
So you'll issue a notice,
Lord.
6th of November. If the present writ petition is filed assailing an order dated 6th of November 2023 issued by the Principal Secretary to the Government of Assam, Department of Tribal Affairs, within bracket plains, whereby the petitioner who was appointed as appointed initially as member of interim council of Boro Kasari Welfare Autonomous Council has been removed as a member of, whereby the petitioner has been removed as a member of 20%. Issue notice returnable after 4 weeks.
Lord.
Returnable after 4 weeks. Who accepts notice for whom? He's in town. Okay, Ardhar accepts notice on behalf of all the respondents.
1, 2,
3 and 4 probably your lordship should have. 3 your lordship should have.
they have to take by register.
3 and 4.
What 3 they submit?
Only 3, only.
Only 3.
Only
There is
three.
no,
Only 3.
no 4.
So rest are 4 and 3 is to register for. Okay.
Other that in the court this matter art on
Okay. Registry to list this case reflecting name of Mr. Art.
And along with WPC 565
I got लिखो. Earlier to the impugn order by an order dated by an order by earlier, see the earlier
Lord.
by an order dated Swenso, the petitioner was removed as chairman of the said council
4th January 2000.
4th January 2023. Such removal as chairman is also has also been challenged in WPC 565 of 2023. In view of the aforesaid, both the writ petitions be taken together.
Repealed.
May I please your lordship?
Mm.
Here, my lord, that is SBI has taken the top share by account. You want wrong, maybe they're showing that. my
Now,
wife-
what to do today?
No, today, my lord, because they are penal council, or at the best, I can,
Just
lordship, if I call, lordship, penal council is there, lordship, ask them to take instruction. So this, my lord, only 3,700 rupees.
no, we understand. That's why we're asking what kind of
Now,
order.
that is now one
Wife
way
was
they
a
are, my
great
lord,
wife.
in this situation,
Wife
whatever.
might have some loan. So your case is that
I'm not a
heard Mr. C. Borua, learned counsel for the petitioner. Also, the grievance of the petitioner is that the petitioner's savings bank account bearing number 367008293777
SDM Group.
at SBI Amkuri branch, district Sibsagar, Assam, has been
Stopped.
has been stopped.
The incident of my lord, branch manager,
Is the grievance of
SBI
the
Khanapura.
petitioner that the branch manager of so and so has abruptly stopped the functioning of bank account number so and so. It is the case of the petitioner that the said account is the only account in the name of the petitioner, and petitioner receives his family pension.
Family pension yet.
Where do you read family pension?
Family pension not yet received, not yet forwarded, but they are apprehending that to stop this. They initially.
Okay, so you also stop the family pension for now.
No. Family pension is been not at all sanctioned now. It is a
Okay,
department.
then there is no anxiety. We
No.
thought that moment family pension is given, they will take it.
Yes. Now, but family
Issue notice.
allowed to operate at least might to get Prime Minister. What is it? Pradhan Mantri Kisan Yojana, we get 6,000 yearly. Last February 2000, I got it. Thereby my balance has got 3,000. I am unable to take out.
Petitioner
My
submit
son is
that
dead.
submits that the said bank account is the only bank account wherein the petitioner, wherein the money sanctioned by the
PM Kisan.
state authorities under different beneficial scheme
Right.
are transferred to it, including Prime Minister's
Kisan Janman Nidhi Yojana scheme.
Sanman Nidhi Yojana scheme.
Yes.
Full stop. Considering the system, it is further case of the petitioner that petitioner is a very petitioner belongs to very poor strata of society and
Having son of 12 years. Who
and
is to school going.
is having a son of 12 years, and in the event such account is not allowed to be operated, he and even his son's education will be stopped. We understand their anxiety is that your
Yes.
family pension will come, your husband, wife. Yes.
Planning
In-
game.
Can you serve
The,
Huh?
Otherwise, I can give to local headquarters, chief general manager.
okay,
took
in
it to
that view of the matter, let a copy of this writ petition be served. It is stated at the bar that there is no standing counsel for the State Bank of India.
The only penal count.
Considering the matter in entirety and nature of urgency, the petitioner is let a notice be issued to the Chief General Manager and Chief General Manager
And presently, SBI, Khanapura and SBI Amguri.
Chief General Manager local Chief Respondent number 1 and Respondent number
485 pilot. Because 2 and 3 are belong.
Respondent number 4
and 5.
and 5 through the stick.
Yes. As I'm going.
through Dusty. And when? On 28? Huh? When?
If I get the order,
20, we'll get the order by 21. Tuesday. Huh? Huh. What 2nd of April? Will he starve? Yes. 28. Huh?
hello.
At the motion column itself, the petitioner shall serve such copy upon the a copy of this petition upon along with the order of this court upon the aforesaid respondent and file an affidavit
Right.
before 28th. You file it on 27th
I'll-
and then we can pass an order.
Yes. Right.
I take with you. He says that there is a wrong entry.
Lordship may issue some direction regarding time frame, they may will correction and thereafter.
But we do not know whether correction is required, whether he is the actual man. It has orders, we do not want. Hard. Mr.
MH Soikia.
MH
Soikia.
Soikia, learned counsel for the petitioner, and MS Hormone.
2 and 3, my one is
No, we are not issuing notice at this. The grievance of the petitioner is that the petitioner is entitled for how much?
95,100
95,100.
each.
Its petitioners are entitled for 95,100 as per damage compensation as ascertained by the circle officer. It is the further case of the petitioner that the account number of the petitioners,
IFSC code.
Huh?
IFSC
IFSC code,
bank.
and bank details of the petitioner has wrongly been entered in the system by the respondent authorities, and for the aforesaid reason, the petitioners are the money sanctions are not transferred to the account of the petitioners. However, the other persons enlisted, however, in respect of the other persons enlisted in such land, the amount sanction has already been transferred. Considering the above, let MS Burman, learned counsel, representing the state respondents, obtain instruction in this regard as regards actual facts for not transferring the money. List this matter on April. You will not issue a notice. Motion column around 18.
public.
Who died?
Husband of
Husband of the petition. Husband of the petitioner disposed of 6 months. 6 months on sleep.
Sleep.
Disposal. Hard. Hard learned counsel for the petitioner. The petitioner is aggrieved by a determination made by insurance determination dated.
28
Where is that?
page 82.
And order dated. An award dated. File of award number. Challenge is an award number so dated
28
28 to 2024. Issue notice returnable. Give a date last part of April or first week of May.
or date
We understand. You ought to have thought of doing this before the insurance policy. With a huge promise of huge return, you trapped. Huh? Give April last quarter. 29th of April. It's, huh? Does the permitted? Yep. Affidavit. Yes, Mr. Sarah, will you share notice?
What happened? Without view of the court, not be benefit. So earlier also, BIA case also.
That will be difficult.
That-
Kind of a policy. Is not it? It's a kind of a
Hello,
policy
let me see
where they said that this should will
So
this
you
will.
let me see the section, whether it's all the section. And
Therefore, what we are proposing is
No, what I'm
when
saying
will it will be given effect?
What is the effect of? So when you put local is no problem at all. I am importer.
And what about what about filing this petition by this petition? How they are having no institution, no organization.
What a warehouse we are bringing to good here.
Warehouse will it that under section 2 within
You know,
brackets
the question is that
C.
importing the goods from outside and sale here. I am importer. Now importer may not what happens. The question
You are having a warehouse, nothing here.
so I am expecting the goods from here. My office is there here.
But will that give us a jurisdiction?
For the action will arise because the goods are which are there. Restriction is in the
That is another aspect of the matter. Anyway, that is not so serious.
document. A minor meeting was held.
Okay, since you are pressing for interim order, we'll have to pass an order either granting or rejecting. So let this matter be taken after this other matter.
I'm just submitting.
Yes.
A meeting was held of the stakeholder.
Hmm.
And thereafter, various representations were submitted by the including the document for the better of substitution in the press. In the meantime, my representations which have been submitted, they have not been considered and passed order also. Let them pass the order. I've raised all the points.
When after you're raising the points, they have issued the notification, that means it's a rejected.
After after passing of the order, the meeting was held. You lost me see the meeting.
Where is that?
You lost me see the meeting was.
So what kind of order are you proposing?
I am proposing after the passing of the order, a meeting was held
Okay.
of all the stock.
So you file a representation.
We filed various representations pointing out the various difficulties.
Okay.
Now they are lying as it is. They have not passed any order at all. So if they pass the order on that, then
We'll dispose of this petition.
at least at the interim stage, till when the matter is considered for interim prayer, after 1 week or 3 weeks or so, in the
There shall not be a bar for consideration.
if the dispose is the implementation, then you also will come.
Then there may be another cause of action that our representation is rejected. Or there may be a cause of action, this has become infructuous.
You also will come to know that what are the reasons for which they are doing it. We have raised various grievances. You also may issue notice on the interim prayer, and in the meantime, let them dispose of the representation. At least you also will come to know that what are the reasons.
No, my idea is this. If you want to disposal of the writ petition, we'll dispose of this writ petition, go back. And if you want to say that we'll consider the interim or notice, let them respond, we'll consider the interim.
If you also may dispose of, then also may say till that the repentant has disposed of. It will not be given.
No, this is will not do.
Will
will
not,
not.
if you also
So therefore, we can say issue notice on interim, and pendency shall not be barred to dispose of the writ petition filed on such.
pending does not be barred, but in the meantime, they may dispose of not.
Moment we say dispose it of, it will be our direction. And that direction will have to say that, okay, since we are asking you to reconsider it, you will not give.
Will also issue notice on the prayer after 2 weeks.
Okay.
And on that day, the interim prayer may be done.
Yes, notice is of an interim. Notice, notice except by whom? This the present application is filed assailing an order dated.
Page 36,
Order dated.
Is the order dated?
Order number. Order number. Issuance of silo.
And
Pencil mark.
order.
two orders number so and so and orders
And
number
the
so and so
complete
issued by the respondents restraining import of certain wood products, wood products in exercise of power,
Instead of restraining, Lordship may regulating.
or regulating import of certain products
Without the
in purported exercise of section 16 of the Bureau of Indian Standard Act 2016. It is the case of the petitioner that the course of action taken under 16 is not permissible. Full stop. Inter alia amongst others. Full stop.
It amounts to restriction of the
Okay, in as much as such exercise amounts to restriction of the import. Full stop. This matter needs further consideration. Accordingly, issue notice returnable on.
After 3 weeks, Lordship, in the meantime, we will
No, no, why
obtain.
to the Lordship?
Then 2 weeks, any day, Lordship.
Immediately after Bihu vacation.
Lordship.
Give a date. 18th of April,
for consideration.
Lordship, instead of 18, 19, Lordship.
19th of April 2024. Also issue notice on interim on the same returnable on the same date. Steps all are represented. Give the slip extra copies within a week. The interim prayer made shall be considered on the next.
Lordship, I need top copy, Lordship, because our office.
You can request the junior
Yes.
expert to request the court.
Okay, I will not pass any order. Give the
Let
Lord.
will be giving.
Oblige, Lord.
yes, any instruction?
Yes, yes. I have.
55.
Well, I have received the instruction from the district commissioner.
Mhm.
Well, in fact, the earlier this chief executive officer just before his retirement has given that particular order. And there was no process initiated. In fact, inquiry report is there. There is no document in the kindly follow see the fourth page. This is the report.
Just a minute.
There are
Lordship will kindly see your Lordship. Some order has been passed by the chief executive officer. A tenancy agreement has been executed, your Lordship. No action certificate is issued. Tenancy agreement, your Lordship, registered tenancy agreement. Against that 5 lakh rupees I have already paid, your Lordship. I have started to develop it, your Lordship. Now, your Lordship, ultimately, your Lordship, this property belongs to your Lordship, Panchayat, your Lordship. The deputy commissioner, without putting me to any notice, anything, your Lordship,
well,
can pass such an order, your
that
Lordship.
process has been initiated, my lord. Kindly see the record, the report. In the record,
See,
there is
Mr.
no-
Nath,
my lord.
the difficulty is
Look.
the system runs under rule of law.
True.
Isn't it?
True.
A registered lease deed is there. You say that this has been done by an officer before the time of retirement, without
Any process.
without any process.
There is no record in the
Okay.
no
So do
document in
you
the file. in
propose
the
to
office.
say
Correct.
that state will have a power or a government will have a power which is being run under rule of law to take their own decision that this is bad and seal a property violating a person's right under Article 19(1)(g)?
No.
If
No.
no, then we are staying it.
My lord,
Third.
now, my lord, kindly see.
Yes.
There was a my lord, lot of complaints are ultimately, the deputy commissioner has to intervene.
More you are arguing, another point has come, that there are serious allegations against them. Where is the notice to them
No,
that these are the
No
allegations?
allegations.
Where is the notice for cancellation of the lease deed?
No, process has been initiated. That
It
definitely they will do.
can that process be part of sealing? You get it cancelled, you give him a notice, get it cancelled, then seal it.
But-
You cannot seal it right like
when,
this.
When it has come to the notice of the commission,
Mm.
that without there is no document in the file regarding initiation of any process for allotment, when these things have come to the notice, whether or not the deputy commissioner has stopped him from going in. That is the
That is fine.
So-
But can you seal a building like this where a tenant, a prima facie tenant is there? Will not go to all details. You cannot go into all details because there is a registered lease that may not be done by an authorized person. Now tomorrow a day will come, if we are permitting you to do this, somebody will decide this is not my signature, this is not my sale list, throw him out. Throw him out. Give a lock.
probability.
Who is deputy commissioner? Deputy commissioner is under what authority he is having the power to decide that lease deed executed by the registered sale deed is bad. So and so. Therefore, let him be judge, jury, and executor.
Deputy commissioner
That is what he has done.
Deputy commissioner is not acting on his own. He has
And what?
on the basis of the report of the present chief executive officer, he has done this. Kindly see the page 4. What I would like to submit. Kindly
No,
take
you just address us.
Lord,
See, you just address us. If you propose that these kind of facts should be decided by a writ court, will decide. Then the whole state will be on difficulty day after tomorrow.
Lord,
From
that-
contracts to everything will decide. Okay? In a judicial review.
Lord,
Our concern is, where is your power to seal or lock down a business establishment in the manner you have done it? More particularly, when these petitioners were before this court recorded everything and sought for an instruction. Reason as to why the tenant premises has been kept under lock since 19/1/2024, invariably on the next date of listing. This order was passed on 28/2.
Yes.
Okay, it was pending. And we have seen in many cases, you don't have these people, I'm not saying you means your client, you don't have time to give instruction. And what you do, 28 that order has been passed, and what is your action now? Let us see. Where is that order?
Page 50, your lordship, and 51.
Page 50. This kind of behavior used to be done by the individual litigants, not state litigants.
that is one part.
Yes, that
Ultimately,
see on where is that?
Page 50, your lordship, 23rd February 2020.
it was before the honorable court order.
Hard,
Lord,
Mr.
it may give you 1 week time. Let me file the affidavit in the matter. bringing
You
the
file it,
instruction-
you file the affidavit, we'll quote it. Heard Mr. Borthakur, learned counsel for the petitioner, also heard Mr. T. Nath, learned counsel, appearing on behalf of the respondent numbers.
But I am appearing for the respondent number 2, 3, 4.
Respondent number 2, 3, and 4.
Four.
Who is for 1? District Commissioner Gwalpara?
No.
No.
One is Panchayat PNR. Lordship, I am referring to
Okay,
the
okay.
last
1609.
160.
Okay.
156.
Mr. Dotto appears for
156.
Dotto for 16 is 1, 2.
156.
Okay. The the mother other order to 28 to 2024. 2 number paragraph. Come on. Being aggrieved, the petitioner approached this court by filing WPC 592/2024. This court, while issuing notice of motion, under its order dated 28/2/2024, direct the respondents, learned counsel for the respondents, to obtain instruction as regards the reason as to why the tenanted premises has been kept under lock since 19/1/24, invariably on the next date of listing. Said writ petition is directed to be listed on 27/3/2024. Before the matter was listed, before the next date even reached, it is alleging that additional district commissioner of Gwalpara arrived at a tenanted premises with a team and prohibited the petitioner from further using the premises, and the lock was also put there. No, not on that. No. Thereafter, the district commissioner issued an order dated served an order dated 23/2/2024, and whereby the executive magistrate was directed to seal the market complex in question. Full stop. Accordingly, this court directed to list this matter along with the earlier writ petition, that is WPC 592 of 2024. Mr. D. Nath, learned counsel, has obtained instruction from the district commissioner Gwalpara. The instruction, the sum and substance of the aforesaid instruction can be recorded as follows. The lease deed executed between the petitioner and the Zilla Parishad was executed by the earlier chief executive officer just before his retirement, and there is no record of such execution of sale.
Settlement process.
There is no executions, and such lease was executed without initiating any settlement process to tender. Full stop.
Giving wide publicity.
Giving wide publicity. And therefore, to correct such illegality, the lock has been, the property has been sealed. Full stop. This court is prima facie of the view that in the backdrop of an admitted position of execution of a lease deed by the chief executive officer of the Gwalpara Jilla Parishad, the tenant cannot be evicted by the state in the manner they are trying to do with it, even if there is some illegality in execution of the lease deed, inasmuch as such defect or illegality is required to be corrected through due process of law, not in the manner that has been done. Accordingly, as an interim measure, it is provided that the district will reseal it
District Commissioner,
in the matter. The order dated
Your Lordship, 23rd February 2024
23/2/2023
and 28 to
28 to 2023 4 shall remain suspended, and the Deputy Commissioner, District Commissioner Gwalpara, shall ensure that the property is resealed within a period of 2 days.
20 seconds.
Reseal, forthwith. A copy of this order registry to ensure communication of this order. Communication of this order to the district commissioner by today itself. Also equal to.
But the order was passed on 23rd of February
Huh?
before the Honorable Court.
Understand, that also we understand. Let us not go deeper.
My Lord, is
Notice.
'56 and '60, your lordship, from same issue is same, your lordship. This people are your lordship, evicted people from your lordship, Allpur, your lordship.
The
Apex court has
petitioners before this court claims to be landless people. Full stop. This is their case, that they were under occupation of government land for years, they being landless people. However, they have been evicted from such land. Though they made some challenges to such eviction, however, such challenge was negated by this court. Their case is that being landless under the state policy for landless and homeless people, they are entitled for rehabilitation and compensation, which according to them are not being provided to them. Accordingly, issue notice returnable 4 weeks.
sorry. The process is going on, Lord.
We understand. See, we understand. We are on whether notice is required, not required. We can decide that. But it is you who is to decide and balance. If you, once you will say that no Indian citizen will be homeless,
That is
and you evict, and people are under the sky, at least you evict them. First, arrange for the alternatives. We understand when you may need the industrialization, you may need many other.
60,
Huh?
item 60.
56,
26th of April.
56 and 60.
Deeply open.
Please, I am requesting you, because please give the your name whom you are representing. We don't want to spend too much of time on that. Trying to find out who represents whom. Okay? Yes, next case. Which method?
57.
Huh?
57.
57. Okay. What is time barred or notice? Time barred claim or what?
Under 16 2 law,
Okay.
AFL ITC,
Hmm.
the department found that the seller, he is not deposited stake.
Hmm.
So notice was issued.
Now, according to them, seller is under insolvency.
My lord.
Now, what will happen in that case?
No, Lord,
Who's
uh,
it?
If he is under insolvency, the order under section 14 of IBC.
You will have to go to there.
No, Lord.
No.
Then moratorium is declared. Then no proceeding can proceed. As per the informal alignment, that resolution has been approved by the resolution profession.
Okay.
So in that, the lordship that has been removed, the proceeding can be initiated by the department only, but not by the. It is department who has to approach the. My lord, lordship, kindly see page 116, my lord. A press paper is put, my lord, where it is that.
See, admittedly, the due is from his.
No, Lord.
No, I understand. Procedure, you understand. It is his responsibility.
Yes, sir. To reflect in the GSTR.
He has reflected.
No, if that was not there.
You have not reflected.
It is responsible to seller, my lord, not the petitioner. Seller. Now, Lord, the
But
provision.
you have claim benefit.
Because I have purchased the thing, I have paid tax at the time of purchasing, I have valid tax invoices, my lord. On the basis of that, I have claimed, my lord. And my lord, the department says, my lord, if there is default on the part of the seller, if they have to first approach the seller.
So, according to you, while purchasing the product from the dealer
Right.
or whosoever, what was the component you have paid to
Right.
him? It is his responsibility to deposit.
My lord.
So when there is a proof of deposit, how can you fashion me with the liabilities?
Right.
You will have to fashion the other person. And if other person is under insolvency or under resolution, you will have to go to the IBC or resolution and claim it that this is our due. That is his case.
There is a circular, my lord.
Where is that circular?
My lord, it will find it page 120, my lord. The
Yes.
redressal part is 121, my lord.
What action they will take against you?
My lord, department has to go to an NCLT, my lord, approach for the reduce, my lord. Serial number 1, my
Serial number 1.
1, my
Where?
page 121,
121. Okay, serial number.
column 1.
So, in terms of this, no action can be taken against him,
Yes.
against the dealer.
Dealer.
So, therefore, question is whether if you cannot take action against the dealer, if admittedly he has deposited, how can you recover the same amount from him?
That is the lordship. Our information, he has not deposited. The supplier has not deposited. That's why notice is being issued.
Where is that? Where is your notice? Impugn notice.
Final order has also been passed.
Where is the final order?
The relevant part, your lordship find it page 112, my lord.
That's page 102.
102.
Two is the order.
If he has not deposited, that will be a different issue altogether. 102. Where is the determination?
Page, my lord, 100 and
From July 17 to March 2018.
Yes, sir.
only 1 month, my lord. 2 months, January 18 and my lord, February 18. 2 months there is a report.
Determination is page 112.
Hundred and
112. Paragraph 6.1. Paragraph 6.5. Finding is at page, paragraph 6.6.
findings set.
Paragraph 6.6, page 113.
So according to him, there is no proof whether he has received a goods or service or both.
No, my lord. The finding is at page 114, my lord.
114.
One A and B
According to
satisfied.
them, A and B are fulfilled. Okay, C.
C, my lord. Only
Huh.
C, lord.
Okay, so there is no proof that the supplier has paid. Otherwise, it is satisfied.
Okay, recently, Calcutta High Court.
Now, where from he will give the proof of supplier paying? So he is not having he has paid. Clause A is he is in possession of tax invoice and debit note.
Yes, sir.
He is in possession, so his responsibility is gone. He has received the good and service or both, that is done. Then he has furnished the return under 39. Now, only thing is that subject to the provision section, the tax charged in respect of such supply has been actually paid to the government. So whether actually paid or not, actually is to be paid by the
Yes.
Aircel.
Yes, sir.
So whether Aircel paid or not is not there.
6.6.
Hmm.
Lordship, recently, Calcutta High Court passed an order directing the department to hear both the parties and make inquiry whether that
Third, will for the time being, where is that? This is what we need to stay.
the order is page 102, my lord.
This where we are reading it, isn't it?
Yes, my lord. Start from 102.
102.
Lordship, another thing.
We'll examine.
Appeal, that point may be kept open. Regarding
That will kept open. Appeal is fine because he has moment he goes to appeal, what the deposit?
10%.
10%. We understand, but here prima facie case is that your admitted position is that he is not at fault.
This is the law. And that this provision has been put under challenge before this honorable court. This is pending.
We'll keep this maintainability open.
Sure.
Third, we know why they are here
I have
in
no-
most of the cases.
No, no,
Because
it's-
moment they go, they need to deposit. Third, Mr. Gupta, learned- RS Mr. Learned Counsel for the petitioner, also Mr. Kell, Learned Standing Counsel for the GFT. Anybody for any other? Please give it.
Lordship, another thing.
No.
Here, he has to make that person as a respondent. Yes, sir.
But he'll have to make that person respondent means that in that resolution proportional.
This proceeding has been terminated as per information.
So if proceeding is terminated,
Then the company campaign forces some resolution has been passed.
resolution passed in yourself.
Now it's passed. Now it is under monitoring committee. My lord, page 100 there.
Monitoring committee. Now, who in such a case when it's IBC monitoring committee, who will represent them?
So if some-
Okay, you just think over it. For the time being, we are not going there.
Fine.
Heard Mr. Kell. By the present repetition, an order dated 11/12,
My lord.
11/12/2023 is being challenged. Passed by
I have a respondent number 3. My lord.
passed by the respondent number 3. That is who?
Commissioner, my
Huh?
Assistant Commissioner.
Assistant Commissioner,
CPSC.
CGST and Central Excise. Isn't it?
My lord.
CGST and Central Excise.
It was caused by superintendent.
Superintendent.
Page 114. Sorry, my lord.
Huh?
Actually, for respondent number 4. I am sorry.
Respondent number 4. Superintendent. Superintendent, CGST and Central Excise Division, Silchar. Look at page 115, pencil mark. By the aforesaid order, the superintendent has concluded that though the petitioner has satisfied the condition given under chapter condition A, B, and D, satisfied the condition A, B, and D given under chapter 5 of the Central Goods and Services Act 2017 to avail ITC. However, the petitioner has failed to show whether such goods or such goods or service or both was such tax charged has actually paid to the government, either in actually paid to the government. Full stop. The case in brief is that the petitioner received certain supplies from Aircel or what? What is
Disnet Aircel.
Huh?
Disnet Aircel Limited.
Disnet
Disnet Wireless Limited.
Disnet Wireless Limited. In the meantime, the said Disnet Wireless was under insolvency. Full stop. From the order passed by the superintendent, it is reflected that the petitioner has been able to show the tax invoice in proof of payment of the tax in question, and he has also furnished the return under section 39, and he has also received the goods and services from the Disnet Wireless Limited. However, he has failed to show that Disnet Wireless has actually paid the tax received from the petitioner. Full stop. The petitioner contends that the Disnet Wireless being under IBC and IBC, for the fault of the petitioner, for the fault of the Disnet Wireless, the petitioner cannot be fastened with the liability of the GST, in as much as in terms of the notification dated, in terms of the extent notification, no action can be taken against a company which is under insolvency process. This matter needs further consideration, and in the considered opinion of this court, in view of the admission that petitioner has actually used the services and has filed return and pays the tax to the supplier, in the considered opinion of this court, the petitioner deserves an interim order. Accordingly, the impugn order dated shall remain suspended till the returnable date. The question of maintainability as raised by the petitioner for the respondents for having alternative remedy is kept open. Tapes and all of them.
Yeah.
Yeah, we have passed some orders here.
Yes.
Mr. Kyle, who was there? Oh, you were there. Any order passed earlier?
The 1641 order was passed regarding parallel proceedings. The parallel proceedings cannot be taken. Here also they are taking parallel proceedings, but apart from that, Lordship, there is a Lordship specific Lordship case. My specific case is that Lordship, I have Lordship filed my return on time, but I have filed it manually because that time GST portal was not working very nice, and it is an admitted fact. All over India, the GST portal was not working. So what happened, Lordship? I had to file the GSTR 3P within the time period, otherwise my ITC will lapse. So therefore, I filed the return, and the receipt I have. Now they are not accepting it. They have issued me demand some notice saying that no, even if you have filed it manually, Lordship, they will not accept it. But since you have not filed in the portal on the time, I will reject your ITC. And even though I have paid the taxes, they have admitted that I have paid my taxes to the supplier. The supplier have also paid the taxes to the government. Lordship, it is a improvement of the case just before my case. I have paid the tax to the supplier. Supplier has also paid the taxes to the government. If the taxes have gone to the government, now I need the ITC. They are saying that you have filed your return not on time. Now I am admitting, I have annexed that I have filed my return on time manually because your portal was not working. So therefore, I had filed my return manually. I had no other option, but that was filed on time.
Now, where is the impugn action? Where is that?
Lordship, the impugn action, Lordship, I will file that page 95.
95.
2.0.
This is by whom? GST?
Yes,
Lord.
Your
The amount which they have to pay 1,476838.
Where is their admission? That
Lordship, this is the petition by the notice subsequent to the prescribed time as stipulated under section 16(4) of the Act.
where?
Lordship, upon scrutiny of paragraph 2.0, upon scrutiny
Was a paragraph 2.2.
2.0, annexure 3, page 95.
Page 95.
Yes, sir.
Okay, demand comes to cost notice.
Yes, sir. This is my impugnation. 2011-2023, Lordship, 2.0.
Okay, well, we'll come back.
The scrutiny of petition of the financial year on 89. Under the preview of section 61 of the Act, it has been revealed that the statement contained is an inadvertent error. What is that? This error pertains to everything of 80 something to notice subsequent to the prescribed time stipulated. Lordship, thereafter, Lordship may kindly also keep 4.0. Next page.
Just a minute. Now notice was issued. Then
4.0, Lordship.
and where is the difficulty to reply to this notice?
Lordship may kindly say, Lordship, that we had already submitted. They will not accept the manual. They want it, Lordship, electronic. I'll show from the section, Lordship. It doesn't prescribe any electronic or manual mode. Lordship, 4.0, Lordship, I just want to show only 4.0. That they have accepted that I have not committed any fraud, misrepresentation. The only problem is, Lordship, importantly, Lordship, importantly, it should be highlighted.
Just a minute.
Should be highlighted the ability of GST or non-firm in the package system for scrutiny negate any presumption of any fraud, willful misstatement, or suppression on facts in the present case of the part. So, Lordship, I have not. They have accepted that I have not committed any fraud, misstatement. That is the admitted position. If no fraud, no misstatement or suppression of facts have been done in the present case, only issue is that I have filed the return belatedly, and Lordship, I have annexed in this petition the receipt, the manual receipt. Lordship, that shows that I have filed all my returns right on time. Now, Lordship, the section 16(4), which is there in the GST Act, Lordship, that nowhere prescribes that you have to, if you file manually, I will not give you ID. There is a Lordship time limit prescribed, no doubt.
Just a minute. Now what happened thereafter?
Lordship, thereafter, Lordship,
See, they say notice is required to provide an adequate explanation for the following points. First is the reason behind incorrect availment. According to them, it's incorrect availment amounting to so and so. And 300 so and so was intimated to the noticee, but no reply received from their end. Third is that input tax credit should not be demanded, so and so. Then what happened thereafter?
Interest and penalty also, Lordship.
They have asked you.
Lordship, the manual, Lordship,
No,
they
no,
have
we'll
asked-
come to that. What happened thereafter?
Lordship, they have asked us to obtain an order from the court. They cannot give an order so far as manual. They want a demand. They want to recover this
No,
amount.
why have you not replied to this notice?
Lordship, we have submitted the manual receipt before the
No, where is your reply?
Lordship, not the reply to this notice. Lordship, I have
You
submitted.
file a reply.
Lordship,
What was the period?
Lordship, the manual receipts are not accepted by them.
No, that is your apprehension and you are submitting it. Let them give a reason that we are not accepting manual. We will take an action then thereafter.
Lordship, we had submitted the manual receipt before the issuance of the supposed. That is there with them. They are not accepting the manual.
There is no decision to show that there is a they have not accepted manual. Where is that finding? That you have submitted manual and that has not been replied.
Lordship, it is like this.
No, that cannot be in a court of law. It's a court of law. Let us have a chance to say that at this point of time, the system back operation was not available. Therefore, for that period, they are bound to accept manual. A person cannot be deprived of their right of paid tax, and the state cannot be, and they cannot be imposed penalty only on the ground that it was manual. Let us decide that. That we can decide when there is a determination.
Lordship, one more thing is there.
Now, first you answer me, why have you not replied to this 28th of
But this was at least
2023.
the manual receipts were produced before them. Lordship, they
no,
are-
we do not know. That submission cannot be recorded.
Lordship, but
Where is your reply that these are the manual report? Then what is the remedy against this order?
Lordship, the only remedy is, Lordship, either the High Court or there is not the third remedy.
You file a reply.
Lordship, but the only thing is that, Lordship, that at that point of time, when the DSTR 3P returns were filed, Lordship, when we have produced, Lordship, this is relating to a particular year 2018-19.
Hmm.
What they say that DSTR, by way of DSTR 3P, you can avail the ITC, that is also incorrect. Lordship, there was a notification dated 1/10/2022. Before that, Lordship, DSTR 2, by which I can claim ITC, was not notified by the government. Earlier, Lordship, DSTR 3B was only prescribed for a stopgap arrangement. DSTR 2 was the return which was to be filed to avail ITC. Now that return was also.
Now, what is this page 98?
Lordship, this is a parallel proceeding. Lordship, this I have annexed to show the next case. That's a parallel proceeding. For in respect of the same Lordship period, they have issued parallel proceeding. That notice I have challenged in the Lordship next case 61. Lordship, that is a parallel proceeding. They are for the same period. They are issuing a parallel
We
proceeding.
are
That is
not inclined in this case. We must be more happy and more satisfied that this is a case for judicial review. More particularly in the backdrop that they have given you the opportunity to tell what is your story. Why should you hear that story here? Tell them that story and let them take a decision. Will or the appellate authority, whatsoever, will take a call.
Lordship, then Lordship may kindly grant me a prescribed time within which I will produce all my manual
What you
manual
say?
forms.
The part.
Huh?
Just that.
Huh?
If they go in the appropriate.
But whether we can pass that order, what should be that period of notice? This was 2017.
Yes.
For any action taken on this?
Lordship, now the adjudication will come if I not reply. That is the only that will be taken. Till now, no action has been taken. Lordship, they have just issued notice for hearing. They
But
have
this
taken time.
notice is 2011-2023.
Lord.
What happened thereafter? Any date was given in the notice supposed to?
Till now, Lordship, no date is given. After this notice, Lordship, it took time, and thereafter, Lordship,
Yes, what you say?
Lordship, in the page 97, all the things are there. What my lord?
No, that we also know.
Now-
What is your stand as regards remanding this matter back to the authority?
That will be for appropriate forum. But department is the appropriate forum.
Okay.
to-
Heard MS and Havelia Learned Counsel for the petitioner. in the present proceeding, a notice, a demand so cause notice dated 20/11/2023 is under challenge. The notice reflects, according to the department, the notice reflects that, according to the department, after a review of records, they came to learn that the noticee, the petitioner, has availed ITC amounting to rupees 147,68383 for the financial year 2018-19, and such availing was conducted beyond the prescribed time limit as per provision of section 16 of the Act. Full stop. No. Write it like this. Okay, full stop. It is also found in the at paragraph 4 of the notice that the department has found that the noticee had inadvertently availed ITC for the aforesaid amount under existing law during financial year 2018-19, and such fact ought to have been highlighted in GSTR 9 form in the GST back in the GST backend system for scrutiny. It is scrutiny, and therefore it negates any presumption of fraud or willful misstatement or suppression of fact by the petitioner. Full stop. Accordingly, the petitioner was asked to clarify the following points: 5.1 page 97, 5.1 to 5.4. Full stop. At this stage, first, MS Havelia challenges such ground that there is no dispute that the petitioner has filed return, paid the tax. However, such return was manual, and at that time, in as much as at that time the GST backend system was not properly operating, and therefore the authority could not have demanded such amount. She has also raised certain legal issues in this regard. At this stage, Mr. Gogoi, learned counsel appearing for standing counsel for the GST, submits that as the petitioner has been given an opportunity to explain her case, this matter may be relegated to the assistant commissioner, who has issued notice by giving an opportunity to the petitioner to reply to the points as advises at paragraph 5.1 to 5.4. Full stop. Mr. Havela submits that for the present, she may be she will accept such proposal. Accordingly, this petition is disposed of on the basis of the aforesaid consensus that the petitioner shall file a reply within a period of 1 month. Okay.
Date of notice may be specified.
Huh?
Demand comes to cause notice on 2011.
2011, that I have said in within a period of 1 month.
Lord.
Within she can file a reply within a period of 1 month. Will will file file a notice. Accordingly, this petition is disposed of, that providing that the petitioner shall file the reply to the notice within a period of 1 month from today, and thereafter the assistant commissioner of taxes shall decide the matter, taking note of the reply filed by the accordingly its petition.
one lordship covered matter. Lordship, they have issued a parallel proceeding in respect of the same period, and lordship have demanded the huge amount of interest, as well as lordship GSR 2A, their difference between GSR 2A. Lordship, the similar, in similar case, lordship has issued a that parallel proceedings cannot be initiated for the same period.
Yes, Mr. Gopi, what you say?
Yes, lordship.
Okay, we'll examine it.
Yes, lordship.
This is also notice under section subsection B 2 of section 6.
Same lordship is 73, section
Huh?
73. 73, they have given two notices under section 73.
Hmm.
One is lordship which is at page lordship 73, and the other notice is at page lordship
Hard. Ms. and Havelia Learned Counsel.
72.
Also hard, Mr. Gopi. The present repetition is filed assailing notice dated 27/9/2022 issued by the respondent number 3. Comma, it notice that will likha demand cum so cause notice dated 27. Okay. For the period October 2017 to 2019. Full stop. The basic ground of such is that said proceeding is a parallel proceeding in as much as already a proceeding has been initiated by issuing a notice dated 2011-2020. That notice we have remanded 23/11/2023. Full stop. It is the further case of the petitioner that this court has already remanded, not necessary, and that proceeding pursuant to notice dated 2011-2023 is pending adjudication. Full stop. In this regard, MS Havelia Learned Counsel submits that in an exactly similar situation, in the case of WPC 371/2024, this court, having prima facie satisfaction that two parallel proceeding having prima facie satisfaction that in a similar circumstances and a background fact of fact of pendency of a proceeding by SGST authorities, CGST authorities. Okay, let us. MS Havelia Learned Counsel contends that once a proceeding has been initiated by the CGST authorities by issuing the so-called notice dated 2011-2023, the GST authorities could not have issued the so-called notice impugned in the present case dated 27/9/2023 on the same subject matter. According to her, such an action is a violation of the statutory prescription contained in subclause 77 subclause
it will be the same section 6(2)(b).
Subclause B of subsection 2 of section 6
of the CGST Act.
of the CGST Act 2017/SGST Act 2017. Full stop. Note, Gogo accept notice, issue notice, Gogo accept notice. Having regard to materials on record, comma, the so-called notice and the provisions contained in subsection B of section 2 of section 6 of the CGST Act 2017/SGST Act 2017, the respondent CGST authorities it is provided that the respondent CGST authorities shall not proceed further in terms of the so cause notice dated 27/9/2022 till the next date of list.
Biplab. Extra copy maybe.
And that we have.
And Biplab.
Mr. Nath, here is a situation, his case, we are not on the facts of this case. Here is a situation, according to the petitioner, there is no division bench available in the Board of Review. So that will convert this court into a appellate authority under Assam Land and Revenue. So how you propose to do that?
Look, just we try to take some instruction about. I'm told that the process is on and it is undergoing. But they will complete. We need some time. Let me have the instruction.
Okay.
The specific.
Okay, but what kind of order do you expect in this case today?
Just staying for losses.
Early.
Yes.
So let us will not dispose it of, we'll have in the notice stage. Let us fix it in after Bihu.
Yeah.
Okay.
And in the meantime, what is going?
In the meantime, you
will-
can have that instruction. This is not an adversarial litigation. Heard Mr. Kalita, learned counsel for the petition. The grievance of the petitioner is that he has preferred an appeal.
I have
The
one number 3.
respondent number 3 has preferred an appeal. Has preferred an appeal before the Assam Board of Revenue under the provision of Assam Land and Revenue Regulation 1886, which was registered as Appeal 36 RA within bracket J/2022. It is the case of the petitioner that the mutation granted in his favor has been challenged in that appeal, and for want of a division bench, the matter is not being adjudicated, and in the meantime, the order passed in his favor has been stayed. Full stop. Mr. Kalita contends that the division bench is not sitting for want of requisite members in the Assam Board of Revenue. In the aforesaid backdrop, this court requested Mr. D. Nath, learned senior government advocate, to assist this court and obtain instruction whether there is any shortage of member in the Assam Board of Revenue for which division matters are not being taken. In as much as such a situation, if such a situation as projected by the petitioner, is correct, the same will create a problem not only for the petitioner but the other matters which requires adjudication by a division bench of the Assam Board of Revenue. Accordingly, Mr. Nath has submitted that it is correct that there is shortage of member in the Board of Revenue. However, at the same time, the government has already taken initiation for appointment of members. Accordingly, he submits that matter may be listed after ensuing due vacation, so as to allow him to so as to enable him to obtain the exact instruction as regards the process of appointment of members in the Assam Board of Revenue. Accordingly, the matter stands adjourned and registry is directed to list this matter on after later part of not immediately after Bihu, after later part.
Give a date.
Date, that's why 22nd or a little bit later.
On 1st of or
May.
1st of May.
1st of May. 1st of May 2024. Registry to reflect name of Mr. D. Nath in the cause list. Mr. Kolita shall provide extra copies to Mr. Nath. Yes, Mr. Mohanto.
Yeah. My prayer is
Rehabilitation.
rehabilitate.
Then land they wanted to construct SOS village. For that you have been evicted. Now they have constructed the SOS village in some other place,
Those who are lying back.
and therefore you want rehabilitation.
Yes,
Either
yes.
give that land or give
Yes.
something else.
Yes.
Okay.
And they have asked the authorities time and again when we make an application to the SDM or the deputy commissioner, it goes on to the circle officer that it finishes. That's how ultimately it is remaining. So, Lakshmi, can you see the last one at page 32? This was 23. Again, this is pending. Nobody is taking initiative. Nobody pays heed to us. So we cannot. It is their part.
Third, Mr. K.K. Mohanto, Learned Senior Counsel, assisted by S. Gautam. Also hard. Yes, sir, Learned Counsel. For the Learned State Counsel. Will 3 and 4 will say later. The grievance of the petitioner is that petitioners. The petitioners were in possession over a plot of land measuring 20 bighas, 3 kathas, 10 lesas, covered by tag number 335, 452 and 455 at Kisam, Borpukuri, Mouja, Jogijan, under the district of Hojai, Assam, for about 5 decades since the time of their foreclosure. However, the petitioners were evicted from the land by the state authorities as the aforesaid land was earmarked for construction of an SOS children village established of a children's village. It is the further case of the petitioner that at the time of eviction, a promise was made that the petitioner shall be rehabilitated and be given alternative land. Alternatively, it is the case of the petitioner that though they were evicted for construction of the SOS village, however, SOS village has been constructed in a nearby plot and not in the plot where from the petitioners were evicted. Accordingly, the petition and that land is still lying vacant. Still lying vacant. The petition
are now trying to approve.
and if the land is kept vacant, the same may be encroached, and in fact there are some attempt to encroach the land. Accordingly, the petitioners has preferred representations before the authorities, and it is the further case of the petitioner that the respondent authorities has directed respondent district commissioner has directed the circle officer to make an inquiry in respect of the claim of the petitioner for further course of action. Mr. K.K. Mohanto, Learned Senior Counsel, also refers, in this context, Mr. K.K. Mohanto, Learned Senior Counsel, also refers to the Annexer 6 letter issued by the Additional Deputy Commissioner addressed to the circle officer asking for a report. However, when nothing is being done in this regard, the petitioner has approached. Issue notice returnable on divided May. After election, Mr. Mohanto, nothing will happen. Unnecessarily it will be listed. They are busy with the greatest festival of democracy.
But if I may both humbly draw your lord.
Let us have their.
Well, my lord, whatever has fallen from this honorable court has fallen.
No, that is not fallen from my. That is fallen from their pleading.
My lord, page 22 of your lordship brief, and then page 24. This
That
has been
earlier
agitated.
order.
This has been agitated before the honorable court. My lord, and the order is.
See, we will go to all these technicalities when it's a person status of a corporate, not to a person admittedly who were living in the government land, admittedly who have been evicted, admittedly who once some settlement. Admittedly, in the backdrop of a policy of the state, as we know, we have some knowledge everywhere that government do not want your citizens to be landless and homeless. And that government you are representing. Isn't it? So let us not go to all
Very
this.
well, madam. Exactly, my lord.
Yes.
Yes, good, madam.
Yes. Returnable on 15th of May.
Meanwhile,
In the meantime, the where is that settlement of SOS?
the settlement has gone, my lord. It is not there. Bhoniram Patar. It has been settled in Bhoniram Patar, nearby.
Any statement?
There is not a party here. Qatar is not.
Yeah,
Okay,
do
it
not
is
have any claim.
in the interim, it is provided that the state authorities shall ensure that the land in question, if is vacant, shall be protected from encroachment from any quarter.
Absolutely.
My lord. In fact, my case is fairly covered by the last order passed by your lordship, which your lordship will find at page number
10
48.
copies has come.
Lordship, the case paper not.
Where is that?
48. Squarely, not even an inch different. Same milling. Nothing was recovered from.
Okay, we'll pass. Yes, let the scan copies come because it's NDPS. We will have to give them a hearing. You know that better than us.
Not better.
Yes. The scan copies call for has not been received. Registry to issue reminder and
20.
list this matter
28.
28. We'll take a chance. Just inform them. We'll take a chance because thereafter you'll have to do it hard way. On 28. 28. 29th is a working day or holiday?
Good price.
In question of a lot of land, I think it are then.
Why this IA?
I am a lot for the day. Some persons are making construct over the land, my lord. They wanted the filling up the land. So that is why I pay
Where is the
for it.
requisition? Give the requisition. Who is for the private? Any private respondent?
No, my lord. So page 30 of the petition will be seen, my lord. See, then advisory committee meeting is there, my lord, there already. Their portion is, my lord, page 24, then price committee report. Thereafter, person percentage also state, my lord.
Just a minute. Yes, madam. You see 8/3/2022 order. 8/2/2022 says that to obtain instruction regarding status of
Yes.
his land settlement. Now he says that
But
other persons are started construct.
need
So we want
taking
a specific instruction.
Yes.
Uh, We'll pass the order in the writ petition itself. This court under the grievance of the petitioner is non-finalization of proposal of settlement of 3 kathas 10 lessas of government khas land under DAG number 360 of Mauza Garmur, Toklai Tea Estate in favor of the petition. This court under its order dated 8/3/2023 sought instruction from the state respondents as regards status of finalization of such proposal made in favor of the petition. First, MSP in the meantime alleging that some encroachment are being made in the aforesaid plot of land and certain constructions are started, the petitioner has preferred this application for a restraint order. Full stop. M. Bormon, learned counsel, submits that she may be granted when. Oh, no. Then we'll have to pass a stay order. We do not know whose land, what land. Over telephone, whether anything is going on. We are having it on 1st of April.
Okay.
You try. So obtain instruction. Mr. M. Borman submits that she may be granted a week's time to obtain instruction in this regard. Accordingly, matter stands adjourned and be listed on 1st of April 2024, on which they on the said date,
Can you?
3rd of April 2020. On the said date, MS Bormon shall obtain instruction as regards the status as directed by this court under its order dated 8/3/2022, as also as regards the allegation made in the connected IA of illegal construction. We do not know. Let us see. It is 3rd April only.
Okay.
Mr. Saheola, at this stage, Mr. Saheola prays for an order of status. Such prayer will be considered on the next day, on the next. Yes.
We have taken the Dasti Saman of the but that was refused by the respondent over 10 years. We filed the additional affidavit.
Lordship, the ferry service will be over on 31st of this
Yes,
month. Almost infrastructure.
Let it be infrastructure on 1st of
April.
Your Lordship, immediately after the holiday.
Okay. You say that Dusty has been refused.
Yes, sir.
Where is that affidavit?
Your Lordship, we have filed the affidavit on 23rd year. That is there.
Let us complete one stage.
Yes.
Where is that affidavit?
Is there.
Where is the statement?
Statement is there in paragraph number 2 here.
The petitioner has filed an affidavit in proof of Dusty service upon respondent number 10. At paragraph 10, specifically,
Paragraph number 2 here.
paragraph number 2, it is specifically stated that Dusty survey was refused by the respondent number 10. In that view of the matter, service in respect of respondent number 10 accepted. List this matter in the admission column on 7. Then when?
On 28th.
Then what will you decide?
31st.
28th, to decide it will be difficult. It will be full of motions and all. 3-4 days holidays.
Right.
You miss the bus, no way out. What to do? This matter should be done at the earliest.
Lordship, I am for the transport department.
Yes, MD Bora.
Deeply obliged.
8.
Obliged, sir.
Hello.
Yes, what is this IS
Second number for maybe.
NSPID? The present application is filed for striking of National Highway Infrastructure Development Corporation, NHIDCL, from the array of parties within bracket as respondent number 4, for the reason that NHIDCL is having no role either in the impuged action or its presence is necessary for determination of the present litigation. Mr. Borua, learned standing counsel for the NHIDCL is present. He also submits same. In view of the proceed, the present IS stands allowed by deleting the name of NHIDCL as respondent number. From the by deleting NHIDCL from the array of parties as respondent number 4. Registry to correct the first list of the connected with petition accordingly. IS stands.
Right.
No time to dictate. After
It's already out of the. Yes, no.
because this bench was sent suddenly. It's
Supposed to place something. Only I would place one judgment of the matter because here initially I have pointed out before is honorable court. The last one judgment is in favor. I have there is no appeal against that matter. He is regarding the termination of matter. The accident is Delhi High Court judgment matter. Influence of matter. He was in during training. He was accident was there matter, and he was after matter 10 lakh compensation was given matter. That is in his favor. The other I have to argue matter. But what here basic question matter I raised before his honorable court matter. Other court matter. Here the termination order was not challenged in the retribution matter. Initially it was not challenged matter, but when order was passed matter, there is no whisper against the termination order. It is stand matter. So matter whether even Delhi High Court judgment matter is in favor matter without this the.
so your ground is that forget about other things. If he is also entitled, his judgment is covered, plus don't give him relief because he has not challenged his termination.
No, not that. I'm not that.
Then that is the sum and substance of your argument. You say that Delhi High Court judgment covers him. He is entitled, but in Delhi High Court it was challenged. Here it is not challenged, so don't give him.
No, but my lord, if is in presentation, he has not challenged the termination order. And this other this so far this judgment was passed by Delhi High Court. It was not challenged by the department. It was compensation was given. Here also there is two notification from this department. The SGCI is there. So now lordship this honorable court if termination order is considered, the lordship may remand back this entire matter for medical board and after rehabilitation board matter. Then they may decide. That is there. But this if not termination is the order is not satisfied, if remain there, then it will be difficult to reinstate him. This is the other judgment of the apex court is regulating the Assam matter. There is a cabinet decision in favor of regulation. The cabinet decision was challenged by the petition matter, but subsequent regulation of the private respondent, it was not challenged. So apex court says the subsequent they are not interested in challenges of the regulation. So this
no, they are not interested. There is a decision, Mukul Tekya, 2009, 2009, that I will place my lot and when this honorable court finally passed order on that.
Okay, good. Thank you for that.
Just one sentence, sir, I'll read it.
Though Mr. S.K. Mehdi has advanced his argument, however, he submits that he would like to rely on some judgments and advance further argument. Accordingly, leave this matter on immediately after view. Then we'll have some time. 18th of April,
18, not 23rd.
23rd of April, 2024 for further hearing.
Public.
Yes, Mr. Talukdar, from text to
Yes, reversing my lord, various subjects, my lord, now reclassification of that. Hello.
that.
In fact, before proceeding further, if I recollect, my lord,
This
your
is,
lordship-
of course, bench 4 matter.
my lord, the part of
Quarter.
in fact, to recapitulate, my lord, some dates, my lord, may be-
Here issue is whether that another aspect of this, whether that land has already been acquired or it is being acquired.
Acquired, 3D.
Okay. Okay, proceed.
My lord, in fact, what has happened, there were certain applications, my lord, by the petitioner. Now, here is a case, my lord.
Just a minute.
My lord, two legislations, my lord, are involved, my lord, in this present proceeding. Firstly, there is a state legislation. And that state legislation, it is known as, my lord, the
Agricultural Land Regulation Reclassification
classification and
Act
transfer
2015.
2015. Under this particular, my lord, act, certain procedure, my lord, has been prescribed. Now, the deputy commissioner, my lord, is the authority before whom, my lord, the application is required to be tendered. Thereafter, my lord, by other appropriate authorities, records, my lord, reports are received. Agricultural authorities are there, other authorities, my lord. And upon receipt of the
Can we do it like this? Let us finish the other
lord, correct.
matters, then we'll
Yes.
if possible, we'll conclude today itself. If not, we'll have
Correct.
it.
Correct.
Okay.
Correct.
Okay. Let
Mal-
the other matters because it will take some time. It's an important issue.
It will take some time.
Not much time.
Not much time.
In-
For
in-
go,
in-
for
It
go,
may not have much time.
but we
In
need to
principle,
understand.
In principle,
Problem
absolutely.
is this: the judgment is to be written by the judge.
Yes.
That is the problem.
Only principle, well,
And the judge is to give reasons.
yes,
Yes. It may be easy for him, but not for me.
yes. For me, this only simple question is that I have found out.
Okay, we'll take it.
Oh, listen.
Other scholars. We'll hear this matter after some time.
Regarding compensation, I've got a report from the health department. I like to place it on record.
Okay. What is this
Will-
compensation? Any accident or
Yes,
some?
maternal death of the patient.
Okay.
My lord, as per order dated 5/2024, a
5/2.
detailed affidavit was sought for the response of.
But only the that inquiry report has been submitted. That I will bring on record. It will reveal everything.
Affidavit file.
Not fine.
Okay. Mr. Gogoi, learned counsel representing the health department submits that he has received the report and self-filed a
Responded to.
detailed affidavit in terms of Respondent number 2, huh? In terms of discourse order dated 5/2/2024 within 10 days.
Lottery will give me some time so that I can also file the affidavit on behalf of respondent number 3, National Health. There it is awaited. But report I will bring on record. In 10 days I can bring.
And what about the other 3 and 4?
My 3 will be next day.
They
If they rely upon the same instruction, that's a different thing. But
you have it.
Lottery will have to examine whether there is any negligence because there is no report against the my lord department. And in a report, my lord, probably it will be difficult. That will be our channel.
Okay.
We have made petition.
So therefore,
That basis, yes.
affidavit is required. Okay. Prayer is allowed. Please this matter after you give a date.
Yes.
Or first week of May. Let
Yes.
them file their affidavit. Let it be in the May, month of May. On
And my
8th of May.
Yes.
8th of May 2024. The respondent shall invariably file their affidavit in terms of this court order dated 5/2/2020.
Oblige.
Earlier this morning, I prayed for adjournment.
Huh?
Earlier this morning, I prayed for adjournment.
You are seeking an adjournment. Why?
Senior have person figure.
Partially.
Case may be adjourned for the day. Just put it.
Yes, PNRD. SDO Civil Hojai Shankardev Nagar and PNRD department will apprise this court as to whether petitioner has been only singled out and if so why. Who will have that instruction?
I am also, my lord, you will have been communicated, lordship. I have not received
So
any.
personal appearance. Next is. If you have communicated, if you have not responded, then we will not blame
Give me
you.
a last chance, lordship.
Supposed to file affidavit.
Don't be smart now. You sought an adjournment. Take your seat. The learned counsel Mr. J. Hendik representing SDO Civil Hojai Shankardev Nagar, Nagaon, and Mr. Datta S. Datta, learned counsel representing PNRD department, prays that the SDO Civil and the SDO Civil and the PNRD department be given a last chance to obtain the instruction in terms of this court's order dated 16/2/2024. Prayer is granted. List this matter on
After behold,
last chance to in terms of this court's order dated 22 to obtain instruction and to file affidavit There is an order that you should file by 19/3/2024. I think you should pay some cost. There is specific direction. Okay. Good stuff. List this matter on 24th of April 2024. Good stuff. If the affidavit and if the instruction, if the order dated if the affidavit is not filed and instruction is not brought in terms of this court's order dated 16/2/2024 before the next date fixed, this court may consider for imposition of cost upon the concerned officials from their salaries. List this matter. Okay, already the answer.
Yes.
Yes.
I have a humble prayer before Lordship. Subject to convenience of your Lordship, matter may kindly be taken up for disclosure. If possible, today is taken up, my Lord.
What is the issue here?
My Lord, there the
My lord,
petitioner,
there is a direction to produce the record, my lord, by order dated 13 to 2025. Issue for settlement of land. We
What
are
is the issue here?
we are a Bhapat and Vaishnav of Garamur Satra.
Then,
We are earlier Satra's land was taken by the government. It was filling surplus land. We are residing there, and another part our cultivation land is there, my lord. They tried to evict us from our position land.
do you propose that you are tenants under the deity?
My lord.
Huh?
As per stateable
If you are tenants under the deity, then you will have to proceeding somewhere else. We cannot decide. That needs requirement of proof, and we cannot direct for settlement. As simple as that. If you are whom land can be settled under the religious as charitable as acquisition, that says a special area is given to the deity in the name of deity, and which includes orchards and all what not. Now, tenants will have a right to continue, and tenants will have a right for settlement. Now, that whether you are tenant and rights of settlements are there is to be determined by the competent authorities under the Act and under some land. We cannot pass a note, and nor we can pass a direction that settle it. Isn't it? You are very aware. You are a seasoned counsel so far relating to tenants. You know that very well, isn't it? So anything we proceed here may hamper your tenancy right in a proceeding under the space.
If could have then or may have fixed the date, my lord. We have already
Except, just a minute, just a minute. Is there any move for eviction? First prayer we cannot, at any rate, read court cannot issue. Kindly see. You file application in terms either of the land policy or in terms of the act. If you claim that we are tenant, in terms of the earlier act, where land of these religious institutions were acquired, there are certain provisions who will be the beneficiaries, how this land is to be settled. There are prescriptions. First preference, first is for the tenants under the deity, isn't it? Then thereafter landless people, flood affected people. So that can be considered by material, not by this court.
We have enforced various documents regarding this. We have enforcing various documents regarding this.
Do you propose that writ court will decide whether you are a tenant or you have a right for settlement? That will open a floodgate. Every case will have to decide. Settlement, suppose you have suppose assuming for a moment, until and unless you establish yourself to be tenant under the deity, rest is up to the government to settle. Tenants means tenant in continuous position.
We are the tenants.
If you are the tenants under continuous position, this is not the forum, because you need to establish those rent received, how the tenancy was there. Friday. Mr. Sharma, Friday. Not a case for Friday.
in that case, my lord,
See, if we dismiss this petition, we have to give proper. You think over it, Mr. Unnecessary disease pending in the time you are losing valuable time under the act.
Why I am insisting because, my lord, the construction of the government quarter, etc., all are stopped because of the intervention.
This has been settled all in the name of irrigation.
No, my lord, this big area
Hmm.
has been, my lord, reserved for the purpose of construction of government building.
Then,
But my lord, they have
so that is to be decided whether this land was a land under the deity and you were tenant under the deity.
Because earlier, my lord,
Because that allotment of the land or reserving it for the any government purpose, government or anything is held to be bad.
my lord,
That can be decided. No, this is not a case. Anyway, when Mr. Goswami?
my lord,
The petitioners has preferred this any interim order? No.
my
yes, let us go.
let us go.
In petition seeking a direction to the respondent authorities to settle the land under occupation of the petitioner in their favor.
Yes, they are the purpose of question.
Huh?
Government purpose they are.
They
already,
being
madam.
Sabayats, Bhokots will not do.
Right.
Are you Sabayats? These are the issues, mister. Let us not go deep into it.
This is
Claiming
also disputed matter.
claiming the Sabayats under of Gormur Satra. It is the case of the petitioner that the lands where the petitioner belongs originally cultivable lands originally belongs to the Gormur Satra, and the said land has been acquired by
in dark number 3 and 4.
some of the lands are just will give the gist acquired in terms of Assam, in terms of the act,
Assam State acquisition of
Assam state acquisition of within
Land.
bracket
Assam State acquisition of land
lands within
belonging
bracket
to religious or charitable institution of public nature act
of public nature
1959.
1959. 59. It is the further case of the petitioner that the petitioners are having definite right under the aforesaid act for settlement of their land. Full stop. Though the state respondent has the state respondent has refuted such contention and submits that the land has already been reserved for the irrigation.
Not only irrigation, for various departments under the state of Assam.
My lord,
government
has been reserved for various development projects, including construction of office and the quarters.
DC code.
And
DC code.
and this deputy commissioner's office. Therefore, the deputy commissioner's office. It is further submitted that even if assume that the petitioners are having any right under the act of so and so, such determination cannot be made under this case, inasmuch as except the tenants, the others are having no right to continue with land, more particularly in a situation when the land acquired under the act has been reserved for specific purpose by the state.
In this connection, my lord, they have asked to produce record by order dated 13.
Okay,
material available, my lord.
Okay.
With us. Will be
Mr.
sufficient
Goswami
to
submits that they have filed their affidavit and expresses some urgency in deciding this matter, as there is an interim order of status cooperating, and according to him, for such order, the state is not being able to proceed with the development. Full stop. Mr. Learned Counsel for the petitioner submits that the matter may be fixed on a hearing date for final.
4th of April, my lord.
There is allowed list this matter on 4th of April.
Or my lord, 1st week of May.
Okay, first week of May. First week. Give a date. Because April there will be very less days for working days, and we have fixed many methods.
There is election.
Then my lord, 2nd of May.
2nd of
Interim order.
interim order pass earlier shall continue till the next date of.
All right.
These will be the issues, just we have summarized.
Will remain as part.
No. Yes, item number
20.
yes, tell us.
By the last order dated 29/24, the deputy
Nine.
commissioner was directed to demarcate the land in question and to file an affidavit to the state. Also was directed to indicate as to whose name is appearing in the land record of that.
Now what to be done today?
They have not filed the affidavit. They filed the affidavit stating that
We have filed the affidavit today, Lordship. Most probably it has not come to the file of the court, but Lordship, on 20th of March, all the authorities went there for demarcation, but because of it's a dense forest lot, because of that demarcation could not be done because of that rain, Lordship. Accordingly, it is again fixed on 2nd of April. So Lordship may
Okay,
fix
and
it
Mr. Sharma, learned counsel submits that an affidavit has been filed on behalf of
on behalf of the respondent number 3.
respondent number 3. And what we call it?
Pursuant to direction of the honorable
That is 9-2.
Lordship.
And pursuant to direction of this court's order dated 9-2, affidavit is on 9 in terms of 9-2.
Lordship.
In terms of this was 9-9. And what we call it?
But Lordship, that that demarcation could not
However,
be verified.
demarcation.
The verification could not be done because of this rain.
And so Mr. Sharma further submits that the verification could not be done for due to some difficulties.
Rain, Lordship. Rain, dense forest, Lordship.
Due to weather condition.
Lordship.
Due to weather condition, and the next date is fixed on 2nd of April 2024.
So Lordship may fix it in the month of May, Lordship. In the meantime, we can
in
place
view
it.
of the aforesaid submissions, let this matter be listed in the given date of 2nd week of May.
Lord.
9th of May 2024. On the next date fixed, parties shall apprise this court. Parties shall brought the instruction in terms of this court's order dated 9/20.
Lord.
SKMD for renewal. Upora. Yes.
My lord, in this matter, my lord, as per honor, last order, some process is going on, settle the matter.
What going on?
The matter to settle the matter, immediately outside the honor, my lord.
Actually, what is the dispute to be settled amicably?
Regarding the payment of the compensation, my
Compensation amicable settlement.
your lordship, I can't help me last order.
We don't have that much of time to read all this. Just the sub.
Last para of the para 7.
Okay. And the learned counsel for the
2
petitioner.
time may be other.
Huh?
2 time may be.
The learned counsel for the petitioner prays for and is granted 2 weeks time. 6 for an adjournment. Prayer is allowed, please after please.
Okay.
Not paid. The learned counsel for petitioner 6 for an adjournment. Prayer is allowed, please after please.
this matter, the ordinance has been passed as pointed out by my learned friend the other day. But I pray, my lord, that this kept waiting for 6 months. Because we don't know, we have been informed, my lord, that there are some things which may be initiated, my lord, to challenge it.
You want that there will be a challenge to the ordinance, then there will be set aside by division bench, then this will be revived.
My lord, our anxiety, my lord, is that if, my lord, the ordinance is set aside or if it is not approved by the legislature, my lord, the process will once again be back. There is a stay, my lord, on the. That is why. And if it is not passed,
Where is ifs and buts?
lots, my lord.
with a liberty.
Fine.
The present litigation revolves around appointment of new, what do you call it?
MMR, Muslim Marriage
Muslim Marriage Register
and Divorce Registration Act.
under the Assam Muslim Marriage so and so, you can type it, huh? Assam
Marriage. Two, brother, CL number 2, bro. Repeal and saving. 2-1.
Assam Muslim Marriage Muslim Marriage and Divorce Registration Act 1935. However, during the pendency of this writ petition, the said act has been repealed by the state to an ordinance dated 16th of March 2024, published in Assam Gazette, and accordingly, the aforesaid act has been repealed with effect from 16th of March 2024. In view of that, this resolution of this dispute shall remain academic only. Accordingly, this petition stands. However, it is provided that the petitioner shall be at liberty to approach this court if cause of action, if cause of action arises, and if so happens. Petition stands.
So that
Copy of the repealing ordinance is kept for record. In view of order passed in the writ petition, I stand for.
Appearing for response number 4.
Hmm.
Pay for some more time loss. I have already sent this affidavit in opposition.
Who is respondent number 4?
Yes, the development of it.
What is the issue here?
So, my lord, we have received the notice for demolition of our house, man.
Actually,
my lord, the plot
Is there any interim order?
is there.
Okay, enjoy them. Learned.
I am for the restaurant number 6, and I have also filed my
Very good.
they have exposed the government and
What to be done today? He says an affidavit. Since you have come and stood up, so you'll have to submit.
My lord, page 15, they have
Learned counsel representing respondent number
4.
4, press
Four
for
and
an
five.
4 and 5, press for and is granted.
Quick time.
With time to file affidavit in opposition. Interim order passed earlier shall continue till the next date of. Yes, Mr. Borua.
There is a certain submission method. What happened, my lord, the RTC roof of the respondent 7 has extended to in such a way, violation of the that 3.5 feet has extended to the boundary of the now
Who is the municipal authority?
Kitchener Development Authority. Now what happened, my lord? Para 9 I stated, my lord. And this 3.5 feet, my lord, they have also admitted that it was wrongly done. Para 9
Affidavit of whom?
affidavit of respondent 4, my lord.
Who is respondent number 4?
That Development Authority.
Where is the page?
Page your lordship will kindly see at paragraph number 5.
Paragraph number?
5, my lord.
Page.
Page 88. Para 4.
Mr. Sharma, are you in this case?
I have gone to 3.5 feet.
My lord,
No, I am not on that. We are becoming the everything. The appellate authority under the Municipal Act, under the Land Acquisition Act. Even today we became Board of Rate.
my lord.
Affidavit,
Yes.
and in the process, different kinds of photographs. See at page 75. Why this photograph is necessary?
Paragraph
Who is
4.
this man?
This is the chairman, Business Development Authority.
Why he is standing there?
My lord, what happened?
Why this photograph is necessary? His face.
No, but he is the petitioner.
Why he is standing there?
He's standing, my lord, a boundary wall, my lord, have been extended up to 9 feet. So that they are violating. Now, only thing, my lord.
Really? Where is the paragraph? Tell us.
Well, kindly come to their affidavit.
Yes, we'll come to that. Page.
Respondent 4 affidavit, paragraph 4, my lord.
Page.
Running page 88. Let's put the page, my lord, 88 for it.
88. Paragraph.
Paragraph 4, my lord.
Paragraph 4. Yes, tell us.
As per the petitioner letter dated so and so, in a direction to of the Deputy Commissioner, Petitioner Respondent 4, along with Assistant Engineer of Petitioner Career Development Authority had personally visited the house of Respondent 7 on 21/5/21 and found that the boundary wall has already been constructed and the reinforcement of roof slab of the RCC house had been increased by 4.3 feet. And on that time, the respondent 4 had directed to the respondent 7.
Now, what is the urgency? Tell us.
Urgency is, my lord, my prayer number 3, my lord. Page 19, my lord, of my read petition. Paragraph
What?
number 4, my lord. Plus, to direct the respondent authorities not to allow the respondent 7 to undertake any further construction of the RCC roof in the building with a direction to remove the forcefully extended boundary. Now, recently, my lord, the petitioner, my lord, he has repeatedly come to Guwahati and saying that, my lord, they started construction of first floor without maintaining that 1.5 feet. Admittedly, 1.5 feet is a disputed area. That's why we have.
Okay. So there is no stay. Very good.
Also, Lordship,
We are staying this then.
No, Lordship, I-
Since you are doing no stay, then we are staying.
Lordship, we have not started construction. In fact, they have waited. They have also given the
This, my lord, this.
Can I point out two things?
Who is for the municipal authority?
Belong to the development authority, not the municipal.
Yes.
Development authority.
Yes.
Before he's submitting the petitioner is confused how the roof slab extended over his land.
Where is your decision?
Lordship, I am not.
Where is your decision?
Lordship,
That somebody has filed a complaint?
No, Lordship, kindly. In this petition,
Hmm.
the petitioner enact number of documents.
Hmm.
There's some extent of documents. The petitioner said the roof slab is 3.5 foot encroached. In some documents, say 1 feet roof encroached.
Forget about them. Throw him out.
So therefore,
So,
they give the first representation on 7th of.
now tell us,
Yes, sir.
you are an authority,
Sir.
statutory authority. You have some duties and you have to do certain thing in a certain manner.
Sir.
Is that it? Now, there is, according to him, 4.3. According to you, you went there and visited, and he agreed that if it reduced to 2, it is fine. Okay? Can you act upon such promise? Whether this is 4 or 5 or 6, we want to know what should be as per the municipal act, and if beyond it, whether it is compoundable. If not, what action are you taking?
Non-compound.
As simple as that. Who are you to have a compromise? Can the citizen be allowed to suffer? For somebody, suppose he gives a consent that both of them agreed that you kill my wife or kill me. Is it not be a crime?
No, Lordship, at the time of constructing as per the letter issued by him to us, that is 7.
Forget about him. Somebody says that this building is in violation. You went there. What is your finding? We want to know it. We want an inspection by you and to have a report. Forget about him.
The report is furnished.
Yes, give us. Show us. And Borua, this is not a court to be decided.
My lord, I am saying, my lord, that building is not compact. Because, my lord, 0.1.
No, where is your report?
No report, my lord. No report, my lord. I am
Kindly, peruse
Okay,
the-
where is your decision on his complaint?
saying no report.
No, sir, I have not made a decision because the sanction
Make a-
clause, can
Make a decision.
sanction clause was sanctioned by me. He approached me that the petitioner violated the sanction plan, and by which the grabbage, the rainfall water.
Forget it. Simple word is very nice. Violated. Forget about others. Now, what have you done regarding violation? Either you'll have to, he has said that violation, you will go, you will visit, you will compare with this decision, you will consult the act, and you will decide, yes, there is violation or no violation. You take that decision. If violation, demolish it. If no violation, and if there is a order of demolition, they are having a right of appeal under before the government.
Lordship,
That's why we want, where is your action? It is your inaction.
Lordship, we direct to demolish the 2 by 2 feet, and kindly peruse the Lordship report and the kindly peruse the page number, Lordship.
What is your find? You are not understanding.
Lordship,
Nothing is here, my lord. That's why, my
demolish, Lordship. 2 feet has been demolished. Kindly.
No, that is not the issue. See, 2 for 3 feet, this is not our lookout. Our lookout is that somebody complains that my neighbor has constructed a building in violation of the rules or whatsoever in the NOC. Okay. So therefore, you being the authority and statutorily empowered to take action, it is your bounden duty to proceed in the matter and take a call either rejecting his petition. Why are you saying this? They have, somebody has given consent, 2 feet will be, I am happy. He will say, no, I have never said 2 feet. What is this? Is it a private litigation? Is it an elected body? Who are you? He's the executive officer.
Yeah.
Chairman is elected.
Nominated.
Nominated.
The honorary post.
Huh?
It's the honorary post.
Don't perform. You have failed. We have a power in the report to stop you from functioning.
In this case, lot of the DCS continue directed do the needful action and submit the action taken report. We communicate to both the parties that the 4 feet has been extended. Then immediately directed you are violating law. You cut your 2 feet slab and edit.
I want to see that decision.
That is not yet.
I want to see that decision. That this is the permission. He has constructed 4 feet. 2 feet is permissible. 2 feet is excess. Therefore, demolish. This is called a procedure established by law.
Oh, their affidavit is very different. They say that compromise.
That is what I have seen.
Why they have
Can we do you under? Are you aware of the Priyanka state judgment? No. Just wasted 15 minutes. Don't take his advice. He's your advisor. Don't take his advice. Because you'll start doubting your conduct. Because you say that there is a compromise. He says there is no compromise. So you'll start doubting your integrity.
There is no compromise, but I take my own decision by which I direct you to demolish.
Where is the decision?
Lordship, in page number 112.
That is what I am asking for last 15 minutes. 112.
And it's third 5. Lordship.
112. There is no 112 page.
Lordship, page number 112, annex 5.
107.
letter.
Where is that?
Okay.
Yes, Mr. You are continuing to construction.
I have to take it up now. Let's stop.
Oh, my lord.
Let's proceed with lordship
Line
because there was an order
I am
from-
a legal aid, my lord. Line is a 70-year. He came yesterday.
Yes, show us your decision. I'm not getting it. There is no page. 108, then 112. Yes, then
This is the letter dated 9/9/21. The order was passed on 21/1/5/21. But no.
heard Mr. Borua, learned counsel for the petitioner. Also heard Mr. Borua, legal aid counsel representing the petitioner. Mr.
Gopal.
Gopal for the
Number 4.
respond number 4.
Peter.
P does for us. The grievance of the petitioner is that the respondent number 7 has constructed a building in violation of the building permission, and slabs have been extended toward boundary wall of the petitioner, western side boundary of the petitioner. The deputy commissioner, on the basis of such complaint, deputy commissioner directed the respondent board to, where is the deputy commissioner's letter? Dated 3/9/21. By a letter dated deputy commissioner 3/9/20. Mr. Borua,
yes,
please find out 3/9/21. 3/9/21. Full stop. Yes.
60. Yes.
Okay. Okay. We'll do. Okay. Full stop. People. Directed the respondent board to take necessary action and to report the deputy commissioner. Accordingly, the chairman, Vishwanath Sarali Development Authority, by its communication dated 9/9/21, reported to the deputy commissioner that site engineer has visited the construction site, and after physical investigation found some defects within inverted comma of the enforcement of roof slab, and the site in charge has instructed the respondent number 7 to rectify such defects of the reinforcements of the roof slab with immediate effect. According to the petitioner, nothing has been done in this regard. Nothing has been done in this regard. Where is your complaint to the deputy commissioner?
Page 7 from that.
The fact remains that all Assam Pratibandhi Punar Sansthapan Sanstha has lodged a complaint before the deputy commissioner as regards construction of the, where is that type copy, Mr. Sharma? Page 47? 55. Uh, submitted that the west side of the land, the respondent number 4 has constructed a roof of the RCC house entering the boundary of the land belonging to the Sanstha.
But respondent number 7.
Respondent number 7. And in full stop. And in the result, the some flowers, fruits, mangoes, sapling, etc. has been demolished. Thereafter, yet another complaint was filed before the Deputy Commissioner regarding alleged land grabbing by the petitioner. Same, na? Type 2? Okay. No, I can collect that. On the basis of such letter, the Deputy Commissioner requested the chairman of the Development Committee as to do the needful and report compliance as discussed herein. Full stop. Certain dispute has been raised in this regard. More particularly, the respondent number 7 submits that he has constructed the building as per building bylaw, and the respondent chairman has taken a stand on affidavit that there was construction of 4.3 feet excess slab in the building. However, both the parties has compromised that 2 feet reduction of 2 feet will suffice the cost. In the aforesaid backdrop, this court, in exercise of power of judicial review, will not be in a position to decide who is right or who is wrong, and whether there is any encroachment or whether there is any violation of the building permission. Full stop. The construction of building and a building permission are controlled by
Development. Oh, sorry.
Assam Municipal Act and the Assam Municipal Act, and the construction of building and granting permission and the parameters thereof are guided in the bylaw for
Some notified urban areas. Building
Assam urban areas notified
other than Guwahati building rules
other than Guwahati building rules
2014.
2014.
I also given town and country.
Prior to enactment of such bylaw, the no objection certificate for construction of building as well as the parameters and requirements including setback were guided and controlled by the bylaws formulated under Assam Town and Country Planning Act. As the parameters for construction of a building has already been laid down, and it is the mandate of the law that it is the development authority who is to enforce and look into such parameters. And as held by this court in the case of so-and-so versus so-and-so, that it is the bounden duty of the municipal authority to ensure strict compliance of such bylaw. This court is of the opinion that the dispute as has been raised by the petitioner should strictly be resolved in terms of the extant norms, including the extant norms applicable to the present case. Full stop. applicable in the present form, present case. Accordingly, the petitioner is given a liberty to file a fresh application. This is not a proper application. To file a fresh application before the chairman of Vishwanath Sariali, Vishwanath Development Authority, and on such application being filed, the development authority shall look into the complaint made by the petitioner and look into the issue whether the building has been constructed on the basis of any no objection certificate issued under the aforesaid act, the rules framed hereunder, and if so, whether the building has been constructed in terms of the said bylaw and / extent norm. Full stop. In the event it is found that the construction is in violation of NOC granted, the necessary action that should be taken in terms of the act. It is also clarified that if the the necessary action will also will include demolition as well as compounding of such defects if permissible under the extent. Such exercise should be carried out within a period of 6 weeks, with a period of 6 weeks from the date of with 6 weeks from today. 6 weeks not from today, 6 weeks from 1st of April. 6 weeks from 1st of April. While doing so, the chairman / competent authority under the board shall hear both the parties. Yes. That is, yes. Okay. We'll clarify that. 1 week, 6 weeks from the date of filing of the appropriate application by the petitioner, and such application be filed within 10th of April. Within 10th of April. Full stop. In the meantime, and if such application is filed within 10th of April, till determination, it is directed that the restaurant number 7 shall stop the construction. Stop the construction of the first. Petition stands disposed. You perform your duty. That's all. If it is compoundable, compound it. If it is non-compoundable, demolish it. Don't look into anybody's face. And go to Mr. Borua, go to the secretariat, not here, next time. We'll straight away say that even this court has held that issuance of NOC itself is an order. So that order is also appealable before the competent appellate authority. Unnecessary pending this matter, sir. Affidavit after affidavit, and where it is necessary, no affidavit. Land acquisition, eviction, no affidavit. Yes.
Department
has filed.
Transfer petition.
Okay.
So, Lord,
Okay, it is submitted that the department has filed a transfer application before the.
They have filed a transfer application to the Supreme Court that has been pending for a long time now. So all the high courts are going with the matter otherwise. Not to go with the matter. Immediately after being taken.
Okay, sir. It is submitted that a transfer application has been filed before the Honorable Apex Court for transfer of the matter to the Apex Court. from the transfer of similar issues involved from different high court. Accordingly, it is prayed that matter may be adjourned. The learned counsel for a petitioner has submitted that the transfer application was filed in the year 2023, and the same is pending with pending adjudication. And in the meantime, different high court are adjudicating the issue involved. Different high courts are adjudicating the issues involved, as there is no order of stay of the proceeding. Be that as it may, list this matter after 4 weeks as paid for by the learned counsel for the GST, standing counsel for customs, to the standing counsel for the customs. Interim order passed earlier shall continue till the next date. Yes. Hmm? Yes, yes.
Okay, waiting. Finally, the issue is
Where is your objection?
Page 440.
Page number?
45. Next step.
Heart. You are Mr.
Say Hatimudia.
Joy.
Say Hatimudia.
Joy Hatimudia. J Hatimudia. J Hatimudia. And Mr. Talukdar, learned senior counsel for the respondent state.
Right.
The grievance of the petitioner is that an award that the patta land of the petitioner has been acquired by the state authorities under
LA case number 8 of the first.
no, under which act? That also you are not aware.
2017. Actually,
Gossip Assam Land Acquisition Act 19.
Let us not take the name of that act. How can they acquire? Not Land Acquisition Act. And an award has also been passed in LA case number 8 of 2022. The petitioner, being aggrieved with the award, has preferred an application before the Deputy Commissioner Nolbari, within bracket Annexer 7, which goes to show that the petitioner is aggrieved by the quantum of award in as much as determination of the value of the land. According to the petitioner, value would have been much more than what has been determined. Full stop. In terms of section 12, 64,
reference.
Section 12.
section 12, section 12 of the Land Acquisition of the Land Acquisition Act 1964, under which the land has been acquired, mandates that in the event any party interested is agreed by the determination of value may object to the deputy commissioner, raise objection before the before the collector land acquisition, and the event such application is filed, such claim is to be referred to the referral court under section 12. Under section 12. What is the period? Within 60 days. Any period? No period. No period. In view of the aforesaid mandate of law, the present petition is disposed of directing the collector Nalbari to take note of the objection filed by the petitioner on 12/8/2022. Huh? Take note of take on record the application filed by the petitioner on 11/8/2022 and 12/8/2022, and refer the said dispute to the jurisdictional referral court as early as possible and not beyond 60 days from the date of receipt of a certified copy of this order. It is made clear that if such reference is not sent within the aforesaid 60 period of 60 days, in the event any interest is paid by the referral court for the period of delay at the referral stage, is court the referral court will be at liberty to fasten the liability of payment of the interest upon the defaulting collector personally. Repetition. Until and unless their this is taken from their pocket, they are going to sit over this.
They are simply sitting over.
This is not the only case.
It's a mandate on that.
This mandate. He need not do anything. What he is to do is there is a form of an award in the act itself. He will have to annex this thing, and because this will not be the final, the referral court will fix a date for filing of written statement by board. Then he will give everything. This is my cell lead, this is that. Then deputy commissioner will say, we have made it value on this. That much they are not having. I was thinking of giving him a personal affair. Yes. Who is this deputy commissioner? Nalbar?
Because of this rapid encroachment of the railway land, municipality was issuing the district without making any inquiry. So we filed a petition seeking demarcation of the railway land. Since that has not been done here before this court.
Yes.
As per section 22 and 23, they are to
You are not going to decide anything, Mr. Chakraborty. What should be done today? Tell us.
His lordship can dispose in similar case this order has been passed by this court, or one last occasion may be chance may be given if they
Only thing is that we want an order to be complied. If we dispose it, who are you? Yes. You. No. Who asked for eviction? Who issued the eviction notice? Railway.
Railway authority.
Okay, then.
Although the land is not
that can only be decided after demarcation.
Who is for railway?
Lordship,
already
Huh?
two orders.
we filed the petition for railway. The Union of India has filed this petition
For what?
for demarcation law. Taking
Now what is it there?
Two order passed, all the order, and the order itself revealed that they already they have the right. But kindly
Who says demarcate the line?
only we can order.
You'll come to the High Court and evict. How can that be? Who will compensate?
So they file for demarcation. They just don't. But
Lordship, that
Now
petition-
who are being evicted? They are not before.
look at
They have already got stay.
Yes.
So let us join all these
Yes.
represents together. Heard Mr. Chakraborty, learned counsel
Yes,
for the
Lordship,
petition.
that is under Public Premises Act. They have the alternative remedy to go for the distinctions before
Who?
against the person.
That is a different issue. You can go to the district judge, no problem on this. But if the municipality says on oath that this land belongs to us, then
For
why
that, the demarcation will be necessary.
should we send? So therefore, let this be decided. Why will give a handle to railways?
They want also demarcation.
for demarcation.
That be done, Lord.
No.
Let that be done.
Without hearing these petitioners, we are not going to pass any order. Because both of you your eyes are on the land. That is, we have seen all these days. The instrumentalities of the state are more interested in lands than private brokers. You also want, he also wants. So let us hear the person who will be evicted.
Come up. But there is a gated
After protection, you will promise them we will have a building. Okay? I'll tell my experience sitting today. Then we'll have a building. We'll give you, vacate it, we'll give rooms there because the municipality needs income. Okay, very well. Moment they are vacated, you are not giving. You will not give to them, then they will come to this court. Even court passed order, enter a clause in the agreement that you will give it. Retrieve and dispose of, then you will say that we will not incorporate that. Then contempt, when contempt is filed, you will tell the deputy commissioner they evict them under 18(2). Then deputy commissioner is not aware of all these facts going on. Deputy commissioner registers a case for encroachment, files a notice. Again, they come to this court. Moment it is asked, why have you done it? Deputy commissioner, I am not aware that these orders are there. That we have taken and will do the needful. Why should we give you a handle in that background? Hard. Mr. Chakraborty, learned counsel for the petitioner. The respondent number 5-6 for an adjournment to file affidavit in opposition. He further submits that the railway tried to evict the persons over the persons who are possessing the land, disputed land, though the said land belongs to the municipal corporation. Not municipal corporation. What is it? Your municipal board. Respondent municipal.
Can't be the owner. They can only
We do not. That is his submission. Respondent municipal board.
it be either the government land or railway land or private land.
No. Okay. No. Okay. No. You file it. Your stand is required. Full stop. And accordingly, the respondent number 5 has also filed a writ petition. Full stop. This court is of the view that the writ petitions filed by the persons who are in possession of the land and the writ petition filed by the municipal board for seeking demarcation, as well as the present writ petition by which the railway has sought for a demarcation of the land, should be heard together. Accordingly, list this matter after 6 weeks along with WPC Bhogainath 548320.
Not if this is this court case. I
Okay.
I found it.
Huh?
That's a Bhogainath is a disposed case, similar. I thought
Okay,
similar.
WPC 5720/2023 and WPC 5698/2023 and your repetition? Okay, Lamding, okay, fine.
Okay, fix the date.
No date, no date.
Because lordship, we have to implement some scheme lordship. Or that's why.
You cannot implement scheme over their land. You wait,
That's why we want demarcation.
we'll get it done, not after three. Just- No, no. Yes, Mr. Fukan, tell us. Any urgency, anything that we can do today?
There is a peculiar issue, my lord, because
No,
we had-
peculiar issue will come later. Huh?
we had purchased the
Now,
land.
first question is there any urgency
yes.
or can we decide it today?
Lord, this is
Any
not required
affidavit is
elaborate-
required?
So they have been placing written instructions for your lord.
No, no, we understand. Tell us whether any affidavit is required.
It's not required.
It's not required. Yes, responded, no affidavit required. Now, what is your prayer?
I have to just explain very quickly, brother. In 2007-8, we purchased percent of land. We parceled the land plot by the petitioner. Because they had rejected our application for mutation, saying that a writ petition was pending, my lord. And there was
Oh,
an
there,
interim order.
Kamakha.
Yes, my lord.
Okay, then.
My lord, that your lordship had disposed of in October 22. And your lordship had indicated clearly, my lord, in the directions
Now,
that mutation shall proceed in accordance with law. I filed my representations to representation.
No, no, mutations are not on the basis of representation.
No, I had filed the initially I had filed, my lord.
No, there is a now the procedure are a little bit different.
I had applied in accordance.
What is that law?
My lord, the is the objection. The
No, forget about. How have you applied?
But I have not placed those documents on
That is
record.
very vital because nowadays there are some provision and government of Assam has brought on some act which prescribes certain procedure time bound. And there are even appeal. This mutation also comes under that portal.
They have not opened that. They have not opened the mutation for this area. That is my difficulty. They have not even initiated the process.
So that will. So you want a writ of mandamus to open the mutation in that area.
And in fact, they
And you don't file. You need not file any affidavit in this regard.
Sir, may I only say, my lord, 8th November.
Also, we are issuing the writ of mandamus. Open the mutation. Yes, yes. Okay, we'll allow then. If you don't need, no need to file affidavit.
My lord, only my instruction
Draw
is
your lordship's attention before my friend submits to two orders. My lord. 8th November 23, my lord.
Yes.
Where the issue is crystallized, my lord.
This judgment has attained finality.
Yes, yes.
No DB.
No challenge to my one. Lordship had indicated specifically in that you did proceed in accordance with law. That your lordship would find at page 188.
Mr. Talukdar, issue was like this. We do not want to. What kind of that's why I have asked you. What kind of order are you expecting today? A writ of mandamus.
My lord, may I just see my prayer at page 21.
Tell us your prayer.
My lord, I am asking my lord for a writ of mandamus or any other writ direction of like against directing it to mutate the names of the petitioner against the property just mentioned in above.
Okay.
Direct the.
Okay. No, okay.
In second prayer,
Mr. Talukdar, issue is like this. This again, according to the petitioners, this land were under the deity of Ma Kamakya. So, under that act, acquisition of charitable trust, lands were taken. Long writ petition was pending for how many years? 2000.
20 years.
20 years writ petition was pending.
By that
And
was
for the pendency of the writ petition, there was a stay that no transferable land because it was to be decided whether it land belongs to deity of Ma Kamakya or whether it can be mutated. This court has decided no, this portion can only be part of in terms of that act. Rest portion that repetition is dismissed.
The rest of the portions are not.
Not cannot form. But at the same time, we pass the direction that the land granted to the deity in terms of that act should be protected. So maybe for that purpose, mutation is not yet been started because they want to protect that. Maybe we do not know. If you want to say no affidavit is required, we can pass the writ right now the writ of mandamus on the basis of earlier decision. So tell us that you want to file an affidavit.
Map of the area
has
not been prepared.
So prepare it. You will have to prepare it.
It says well only at the time of resettlement, resurvey operation that the fact has to be found. It has to survey. Then only mention.
No, we understand, but that cannot be for a period unlimited. Then
I am not able to put my land to any use. I can't for a
oh, Mr. Fukon, we understand your issues, but howsoever urgent that may be, but we cannot pass a writ of mandamus without knowing the reason that this is not been done.
Lord, I am only expressing my client's Lord Grievance say that not been able to
have this.
Earlier it was different. There was a order. Nobody has vacated that order. Is not it?
Correct.
Then how can you say 2017? There by virtue of a judicial order it was not done. Mr. Talukdar Learned Counsel for the petitioner submits that he will bring this on record. He want to file an affidavit. Accordingly, there is allowed list this matter. When?
My lord.
4 weeks.
Here they have been taking time for affidavit, but then they only submitted it.
Mr. Fukan, understand. This issue has been pending for last 20 years. Is not it? Opening a door for you will be a door for everybody. Is not it? And that involves the land of the deity which we have protected. We do not know. Can we decide this? We are not understanding.
I bow down, Lord. Please. I request for a specific date.
Give a date.
1st or 2nd of May, subject to
2nd of May.
oblige.
Mr. Talukdar, we will have to look into this issue. Whole area, people are deprived of the mutation. Nobody can transfer. Nobody can, in absence of sale. Suppose a person is having a land. Then he want to sell it. His father is having cancer. Who will compensate? You want to sell it. You will not give a permission because there is no map. Can that citizen be deprived of a right like this? So you need to file an affidavit. Mr. Fukon is also not understanding that without affidavit we cannot give an effective order. No, we understand, but don't expect to have a reasoned determination. I will have to conclude that on the basis of written instruction we can do it. We do not want wastage of judicial time. If I can decide, I will decide. I will not shy away from this. But which we cannot decide. We have already spent 15 minutes. That you should understand. You are a seasoned counsel. Which we cannot determine. Why should we waste time? Yes.
Affidavit filed by the department.
My lord, the affidavit is ready as I have.
Okay. Mr. Talukdar Learned Senior Counsel submits the affidavit. That is the respondent number. That respondent will be able to file affidavit within a period of 2 weeks from today. Accordingly, he prays for an adjournment. Prayer is allowed. Please this matter after 2 weeks. Yes, Mr. Bora.
But the second round of the first round, there is already an order.
Temporarily.
As per temporarily, now utilization certificate has been issued in 2022. Everything has been done. Verification has been done. Only the release is remain.
Yes, madam.
I have no
It's
idea.
33.
Today
The Learned Standing Council for Public Works Department press foreign is granted 2 weeks time to have instruction as regards the claim made by the petitioner for payment of undue bill, payments against execution of contract work.
Admitted utilization certificate has been
Inasmuch as it is the case of the petitioner that the utilization certificate has also been issued.
verification.
Have it, have it. Yes.
Mr. Lordship. Lordship, this petitioner is filed praying for the land compensation. For the documentation, therefore, time file affidavit.
Yes, land acquisition
Next is the
compensation, not been paid.
Not been paid.
Yes,
Your Lordship, we need further 3 weeks time. to file
why? Whether you have acquired their land. Number one. Number two, whether you have passed an award. And if yes, why not pay? Three issues.
Order.
Monday, 10:15.
Your
Huh?
It's 3 weeks time.
Why? Somebody need to go there or what?
I mean, but
Yes.
only if they make that if I that
Now 11 Bega is affected. Whether that 11 Bega's payment is made.
Yes.
Payment is made. File an affidavit. Okay. You are Mr. Huh? C. Sharma, Learned Counsel representing Deputy Commissioner. No, the collector. Dima Hasao means collector. Huh? The Standing Council, Dima Hasao Autonomous District Council submits that he has received instruction and shall file the affidavit within a period of 2 weeks from today. Accordingly, adjournment. Accordingly, matter stands adjourned. List after 2 weeks. We file that, then we will send him to the arbitrator, or this is National Highway.
4 and 5, respondent 4 and 5.
No, but acquired by whom?
FPGCL law.
FPGCL. So if that be so, then we'll ask him to go for the whatever remedy available. If they say that we have taken this, so you will have to go somewhere else, not here. We cannot decide that. Okay? So let them the affidavit file. Yes, next.
Apply for.
Yes, Talukdar, what is
Yes,
this?
Lordship. In this case, Lordship, award has been passed. Last occasion, Lordship.
So,
And
That Lordship,
prior to filing of the award, Lordship, PG3 notification also published. So now determined already passed, Lordship. Matter will be referred to the arbitrator.
and giving us
no, I am not the referral
He
code.
has to approach.
I am not the referral code. I am the referral code under section 11 of the arbitration and conciliation. Not here.
to Lordship that
Issue is whether industrial. That you will have to decide there. You will have to show material that these are the land revenue I have paid as industrial. So for all meaning and purpose. That advice now I cannot give. But evidence you will have to leave. It is Mr. R.K. Talukdar, Learned Counsel representing the NHIDCL.
Yes, sir.
NHIDCL submits that the award has already been passed
On Lordship,
on
30/11/2023.
30/11/2023. Do you have a copy of the award?
That's right.
Give it to him. Are you having?
right now I have some award.
Give it to him.
Lordship.
Okay. A copy of the award has also been handed over to the Learned Counsel for the petition. Mr. Mojumdar, Learned Counsel for Mojumdar, FZ Mojumdar, Learned Counsel for the petitioner submits that in view of the fact that award has already been passed, the petitioner shall be granted a liberty, granted a permission to, petitioner would like to withdraw this present petition with a liberty to approach the competent authority for redressal of his grievances in terms of section 3Z within bracket 5 of the National Highways Act 1956. Full stop. Prayer is allowed in as much as petitioner is having a right under section 3Z 3Z5 to agitate his grievances, including the and including for enhancement of compensation. Compensation. Accordingly, his petition stands dismissed with a liberty.
I have a much more clear.
Yes.
The event of that such application is made for arbitration. Maybe you might
The time period spent before this court in adjudicating this petition be excluded.
But there is no limit.
No limitation. That is right. There is no limitation. You can go today. He has given. You can file. Yes. What is this?
Take time maybe around 5 days.
Learned counsel for the
Lordship, government has urgency. On last 2 occasions, petitioner takes time for filing rejoinder. Lordship, I have only one submission, my lord. Lordship, may kindly have a look the order of this honorable court 7/2/2024.
Now, first tell us what is the prayer in this writ petition.
Petition, we have rewriting their permits, Lordship, as per they have given us consent.
You have what you have done.
We have we want to rerouting their permit, vehicle permit to different route, Lordship. And in
You
the
are transport.
Lordship,
What is this permission?
they're flying of route permit, flying of vehicle.
Flying of vehicle.
Yeah.
What kind of vehicle is this?
City bus. Yeah. Our vehicle on 7.
Route is changed.
Opposite our vehicle by notification dated 28/12.
What kind of vehicle is this?
City bus.
Transport.
Why that is uprooted?
Because
Where is the impunity? Tell us.
before that, Lordship,
No, we'll go to that. Let us first understand what is your impugn action. If impugn action is prima facie is not satisfactory, we will not go further today. If we think that that is not prima facie bad and that is hampering the public at large, we'll go further. Don't worry about that. So let us see the impugn order. Where is that?
Page number 1. Page 7. Next are
Where is that RTA board meeting?
Lordship, I have annexed all these documents in my affidavit.
Where is the RTA board? Yes, madam, tell us your affidavit.
Lordship, the RTA board meeting dated 13/12/2023.
Where is that?
My lord is page 90 of my affidavit. Annexer C. Page 90, my lord.
Okay.
Internal page. Annexer C.
Yes.
Lordship, this is the RTA board meeting. Their representative also
Just
were
a minute.
present.
Just give him. What is the decision to
Decision,
deroute?
Lordship, page 91, Lordship, just for a moment. Point number 4, my Lord has kindly have a look. With regard to the removal of 200 number of city buses, the members of the MTAC stated that they assured full support from their end to resolve the issue. Is it decision of 2021 cabinet decision, Lordship?
What is the cabinet decision?
Yes, Lordship. Cabinet decision, my Lord will.
Is this license of buses given to the association or individual?
Individual.
Then
Individual. That's
then
why I'm on focus.
who is this petitioner?
Yes, this is my Lord. Kindly
Now
have
you
a
have
look.
agreed to that. Well,
Lordship, may kindly have a look. 7.2 order
no.
of paragraph 12.
no, show us that notification. Cabinet decision.
Cabinet decision, Lordship.
The learned counsel for the petitioner pressed for filing a rejoinder affidavit. Ms. MD Bora learned
Lordship, I have found page 90.
learned counsel submits that due to operation of an interim order, the not only the department but the citizens are suffering.
Oh, Lordship.
Accordingly, considering the above, the matter is adjourned, enabling giving a last chance to the petitioner to file a reply affidavit if so advised within a period of two weeks from today. If no such reply affidavit is filed, same will be taken on the next date fixed without that.
My Lord.
Please this matter on.
Lordship, I'm on locus, Lordship. I have filed an additional affidavit regarding that. The petitioner has no locus.
24th of April,
Lordship, may kindly
2020.
observe that.
That is always there.
Kindly observe. Lordship, date may be
Give a date.
2nd of April, my Lord.
24th.
Okay.
In this matter, I am appearing for water report. The land acquisition case. As per telephonic instruction we have received, the executive engineer Hemadi on 20 to 24 has submitted a joint verification report to the circle officer Gogamo.
Land is acquired.
Land that I don't know. I have only
Land is acquired without any process. That is her case.
Yes.
For what purpose?
For construction of a dike.
Huh?
Who
will, okay, you can do, there may be urgency, you have no problem on that. Now, who will pay what is the
payment and everything will be done by the
Now we'll have to call everybody in the court. Slowly, this is my feeling.
We'll file our affidavit sometime.
When will you file your affidavit?
Within 2 weeks.
The common grievance of the petitioner is that the periodic patta lands of the petitioner has been taken over by the state authorities for construction of Kumotia left bank embankment. However, no procedure established under Land Acquisition Act has been followed, nor any compensation has been paid. So, the learned counsel for the respondent number
1 and 4.
1 and 4 submits that you will be able to file an affidavit within a period of 10 days from today. Accordingly, matter stands adjourned. The affidavit we filed within a period of 10 days. Please thereafter.
question.
So it is just it was issued on either 23 February.
Awaited instruction.
Mr. J. Henry Planet Council submits that is awaiting instruction. Accordingly, matters can be adjourned. List after 4x.
My lord, what there is there.
Yes.
They ordered the 23 my lord. The land tag number is recorded by the type.
No, that is not an issue. This is an order for notice of motion. That is not. Then you'll have to file an application for correction of discharge.
okay.
So let us not go to that.
All right.
Have you got the judgment?
Yes. The writ appeal, the writ petition, and also the Supreme Court matter.
It went to Supreme Court.
It went to Supreme Court. The Supreme Court just dismissed.
One liner.
One line. In one line. It was dismissed by the order dated 4/9/2017. And it was this is D.K. Sharma, perhaps for the petition. And this is the division bench, this is the single.
I think that issue was dealt here.
Yes, my lord. So I was stating, my lord, the whole case, only one question comes, my lord. The approval they say, which they're saying that they have a right, that their lands were converted. That question has, my lord, been answered there, my lord. That in principle does confer any right or not.
My case will be totally different.
Okay.
Because how did the judgment?
No, we are open. We are open. That was just on that day an idea came into mind because I argued this case.
I will even not
That's right.
my lord submit or argue.
Don't think that I am
No, what I'm
sitting
trying to
here
say-
or standing there is two different things.
My learned friend is trying to overreach me. It is my application, my lord. And all the time, my lord, he is not allowing me to submit.
No, he that's why he's fit. He likes to jump.
Sorry.
That's why he's fit. Jumping is required sometimes.
Then my lord, I will argue totally on a different premise.
Okay.
My submission would be there is state legislation. So therefore, my lord, it operates in a different field.
That's why I have said to you that there may be how to deal with the situation.
Yes, I understand because your lordship has to eventually render the judgment. Now the only difficulty which comes into play, which I have understood, that in view of my lord, the pre-notification, when the Highway Act comes into play, my lord, how come your lordship will balance it?
That is
Whether
right.
at this stage your lordship can say that bring my lord this process to its logical conclusion. That is, my lord, I think the only hindrance. My submission would
Now, next question will be whether the issue and the claim raised by you that actually the character of this land is this, not this. So therefore, I started a procedure whether that can be a piece of evidence before the authority under 3G5 or whether you require a final determination. That can be very well an evidence before the arbitrator. Let's see, this was the stage. So therefore, already there is a conclusion. So you will have to treat this land as an industrial, as not as a agriculture. That can be one way of looking into it. But these are factual. So let us proceed in this matter.
And my lord, my submission would be because 3D, my lord, is not conclusive and precise. Because 3D has to come through a stage. If your lordship finds that 3D suffered on count, my lord, that no opportunity was granted in respect of 3C, and 3C has to be interpreted to be mandatory. My lord, while issuing the notification, CA notification, our land was shown to be industrial land. And in that view of the matter, we did not file any objection under PC.
In that 3A also it was
Exactly, the industrial land. This, my lord, fact has not been brought to your notice, my lord, lordship notice. And this judgment which has been, my lord, placed, I'm not arguing on that premise. My submission will be totally different, my lord.
I understand. Your case will be when it is notified,
My lord.
3A,
Yes.
you cannot, then where is the requirement of this petition?
Yes. Because requirement comes in.
If notification is under 3A, industrial, that is a parallel proceeding, it was going on, even at the stage of 3A or before 3A. Your case is that this is a land having a character of industrial land. In that view of the matter, we applied for conversion. So, not only that, even when notice was issued, it was 3A.
3A.
Now, on 3A, industrial cannot be based on a pending process.
No.
This should be, it cannot be a pending process. So all this, instead of exposing you to all this defense, you should go to the arbitrator, keeping everything open.
Hello.
Instead of deliberating on
What
this
I'm
issue.
trying to say, during the pendency of this writ petition, my lord, the 3A has come in. Now, when we approach this honorable court, the order of the DC has come in the way. Because, my lord, this jurisdiction will also come into play. Whether a committee, when the committee has approved, my lord, in terms of the, my lord, prescription of law, whether the DC would have the jurisdiction. It is not only illegal, my lord, also without jurisdiction. So, had the DC not been a hindrance, my lord, the process would have, my lord, would have stood completed. And only short of receipt of premium, there is an on-principle approval, only the premium was required to be paid. And there is a direction also. I have already drawn your lordship's attention, directing to assess the premium. And with the moment, my lord, the premium was, my lord, about to receive, at that point of time, the letter came. And your lordship is aware.
No, when therefore dates are very vital in this case.
My lord, I'm giving your lordship the date, my lord.
So are we proceeding in this case? Or you say that let me fight it before the arbitrator, or you want some authoritative determination in this case?
Some authoritative lordship will take up, because I have already also got some hint from your lordship. The part has more difficult.
That can be another way to look into this issue. If notification 3A
That's a total misconception.
3D, my lord, again 3D. They have
But if it was in 3A, what was the purpose of filing this reclassification?
No, reclassification,
Yes.
irrespective of reclassification.
Yes. I have a 3A, madam. They no lands are not there. It's not.
3D, they have reversed it. 3A different, 3D different.
I have judgments, madam. The in principle.
We need the fact. Judgments will come later. Judgments will deliver.
No, madam.
No problem on that.
I'm trying to point out, my lord, the whole convention.
I always say we'll require a judgment when we are in dilemma. When everything is clear for us, we'll deliver the judgment. So therefore, we must be very clear on facts, on dates, and on application of law.
Some other day.
If there some other day.
I got it, madam.
Huh?
Otherwise, I have a case.
Okay.
Which will expose everything.
Okay. But we'll not dissect some whatever you say.
No. Lordship will not dissect. On the facts, I will
not go to dissect that this was an intentional notice was known to them, then by virtue of that
part I won't go.
Don't go to that. We are absolutely on legal issues. They have a right under an act. See, they have a right under an act to consider their cases for conversion of land.
Exactly.
Listen, don't jump. Listen to. Now, they opted to exercise their right. They file application and it almost culminated, I'm using the word almost culminated to in a favorable decision or conversion. At that stage, the National Highway right, don't do it.
Right.
The Deputy Commissioner drops this. First question is whether his exercise of his right in that circumstances is exercise of his power in that circumstances is permissible. This is first issue. Okay. Even if we hold that it is not permissible, now what will be the effect of our judgment? This is what is the whether that will be an academic, because by virtue of the notification under Highways Act, the land vested in the government state. So second question will be whether it will be an academic or this parallel proceeding we can make a determination. If we can make a determination that no, this thing was absolutely bad, that event can help you as a material evidence before the arbitrator. Isn't it?
Correct.
We may say that this is not a it has not attained finality. However, this could not have been concluded only on these reasons, which is not permissible under any provision of the Act. Then your communication goes. It may so happen, we may say, okay, if that communication we have, because that may happen in subsequent cases. So therefore, we may stop there only, giving him liberty to go somewhere else. That may help him that no, there was no determination. Now he can lead evidence independent of declaration, because he can claim it to be an industrial right, even if it is not declared. He can claim his value. He can have all these evidences. Many facets of this case.
Yes, correct. And actually, this should have been defended by the government. Or I don't know, but I'm here. My only concern is that my lord.
Where you are National Highway?
Yes, well, NHID.
No,
we have to spell out the money.
No, you will have it a concern because ultimately you are the acquiring authority.
My lord.
You will have to pay the money. Government is the executing. Deputy collector is the competent authority.
Right.
That's all. He will execute, issue the notice on your requirement.
My contention is this, the legal principle, until and unless a decision is taken on a file, it's converted to the decision on a final order.
No doubt about it.
That is it.
But how will you answer it? That is so far relating to decision.
Right.
How will you answer it? Whether a process advices can be withdrawn on the basis of an extrajudicial offer. If we answer it in no, then whole of your request and the closure of proceeding goes, will stop there. Then the entire documentation, entire decision can be a part of evidence from then in arbitration.
Fairly admitting one thing, my lord, that minute, whichever it may go, it lacks application of file.
No, that is not our subject matter. That may be
my concern, my lord.
That may be a material for him for some other collateral purpose.
I'm not saying that he is wrong or I'm right. It may have a good bearing on his case also.
Not the issue of the NHITC also. If the Lordship sees the letter, they are referring to some Supreme Court judgment and saying that it should not be done because they have certain knowledge. While the survey is carried out, they have the knowledge and therefore it should not be done.
No, even that communication could have been acted by the Deputy Commissioner saying that, okay, since there is a complaint, let us stall this project and proceed to inquire whether actually it is yes or no. But what they did is, okay, National Highway says, stop this, cancel.
Yes, they should have proceeded with a...
So whether can we allow an authority, statutory authority, we'll call it a statutory authority, to function in a manner not permissible under law.
So that part Lordship can adjudicate, right? Your Lordship will dismiss it or set aside the order of the Deputy Commissioner. Because your Lordship will see, what I'm trying to say, because your Lordship will kindly see, a statutory process was carried out. Now, if my lord that is allowed,
whether that can be abrogated, the manner it has been done.
So, if my lord, that will be a judicial recognition.
Of course, that is the anxiety.
Yes. And therefore, my lord, any authority can frustrate my lord an act or the process of an act by passing a.
Now you have become wise.
Yes.
Now you have become wise, right now.
No, this is, my lord, one of my arguments, my lord. This will be, that is why I said, my lord, he became a hindrance, my lord, to the entire process. So whether that can be allowed, and this, my lord, my whole petition is structured on this, my lord, particular aspect. And for that purpose,
Gogoi wants it some other.
no, I have no problem.
I said, my lord, but some other day.
Though hard at some length, due to paucity of time, the hearing could not be concluded. Please this matter. How many matters are fixed on it?
It is some difficulty, my lord.
Huh?
It seems some difficulty.
Later, my lord, Bihu, 15.
Before Bihu, my lord.
No, not before.
After Bihu.
Then
Before Bihu, I am not here.
Then
After
23, my lord.
23rd?
Hearing day.
23rd?
Public.
All right, my lord.
So, Mr. Gogoi, that has now, he has, that principle approval
Again,
has
that
gone.
principle also come against him because that to accrue a right, that statute has been rigorously followed. In his case, it stopped midway.
No, that we understand, but stop at whose behest?
Yes, that I will
Whether
explain,
that
I will
authority
explain.
on his behest, can a statutory authority stop working?
That is my case, my
Well, I'll not
The
expose my
legislation has
defense.
been made
I have an answer to that.
Okay.
I will not expose
Okay.
that. Obliged.
Where your lordship, this matter already has been heard at length for 2 days, your lordship, by including both sides. And upon conclusion of the hearing, I was able to show some disparity between the writ petition WPC 1538/2010. Then your lordship, the honorable coordinate bench want to see what is the disparity, and that's why the record of WPC 1538/2010 called for. And there are also some noting of the coordinate bench in the file.
Now, what is your ultimate prayer today?
Ultimate prayer was that your lordship, there was a, sorry, your lordship, regarding the deduct compensation, 80%, 70%.
No, are we hearing this or you are, why then you are making submission, who heard it, why?
That's why, your lordship, I let it become before the honorable, your lordship.
Yes, who was the other side?
I was there. I was
He was there.
I was
Yeah,
there.
he was.
Okay, the learned counsel for the party submits that this matter was extensively heard by a coordinate bench. Yes,
most probably inadvertently that part
yes,
was
okay, maybe.
Yeah, yeah.
And the hearing was almost concluded, and record of WPC 1538/2010 within vacancies disposed of was directed to be listed. Accordingly, a joint prayer is made that matter may be placed before the deadline. In view of such submission, matter stands adjourned and registry to do the needful.
Right.
Mr. Chaudhuri, sorry for forcefully bringing you here.
Because
What
otherwise
to do with
no,
2013?
it's true. Only thing, may I just point out to your lordship, on 18th of January, when it was taken up before Honorable Justice Demarcation, it was pointed out that whether the land in which this establishment is there, has it been established on the land belonging to the petitioner number 2, who is the original landowner. So there is a direction given to the circle office, concerned circle office, to file an additional affidavit stating that the demolished premises is within the premise of the petitioner's land, petitioner number 2's land. That was the limited issue.
Which order?
18th of January. 18th of January 2020.
Who is representing that? We missed it. No affidavit has been filed. Where is that paragraph?
I have placed before your lordship the prayer. After going to the prayer, whether that is why lordship has.
That is why say that
Yes,
anything
lordship.
survives or something like that.
Prayer is at page 18.
Compensation.
Besides compensation also, no. Besides compensation, our another grievance is that whether the demolition was illegal or not, because it was demolished without hearing us. No opportunity of hearing was afforded to us.
So for that purpose.
That was the purpose.
What is their stand as regards that?
They say that it is railway land, coal mines land, because earlier it belonged to the Assam Railway and Trading Company. Then after nationalization of the coal field, it went to the Coal India Limited. So the coal fields are the owners of that plot of land. Now, in our affidavit, in reply, we have stated
paragraph 3.
Yes, paragraph 3 of their affidavit.
Where is their affidavit?
Respondent number 3's affidavit. Page 2 of that affidavit.
Any continuous pagination? No.
No, you're not. No.
Affidavit of respondent number 3.
3. Have you lot of affidavit?
Yes, so according to them, that portion is recorded in the name of your name.
Yes. Petitioner number
2.
Subsequently, also, your lordship, may I just point out, when this order of Justice Devashish was passed,
just a minute, let us understand the order. So it should be reduced in the form as to whether the land belonging to the petitioner as stated in paragraph 2 affidavit filed by the state officer. Now, only affidavit need to file is that this plot of land to this plot of land falls under NLR grant. Isn't it? Then it will be clear whether it was legal or illegal. That is the content.
In fact, your lordship, we had got
Yes, Mr. Samal.
Yes, lordship, I will bring, but even then, lordship, may I make a submission? If it is found that it was demolished illegal, so he can claim compensation. Again, that part too.
That part will get good because
Lordship,
then
that is
only thing will be that we'll say that this was illegal, assuming for a moment, depending upon affidavit and what they argue, and then say maybe we are saying that yes,
then lordship may
he was a good man. Now what his level of goodness will be determined by civil court.
Lordship,
Still interested?
Yes,
your client.
Yes,
In other case, they have filed a suit of dismiss.
Which suit?
Second.
That's Sohai Saran Coke Limited.
That is dismissed. Who dismissed it? Any matters?
A petitioner filed in the suit.
No, that is, I am told by the my client that this is on a different footing, so that may not be.
So this is you are not there in this.
No.
Same.
They are also claiming compensation. Adjacent land.
So let us dismiss this petition for today. Do some work.
Yes.
Do some work. Why should we keep it 2015?
No, your lordship, what I suggest is that let them file an affidavit. Now, limited question is.
No, we are limited question. You're okay because there is a judicial order.
Yes.
That both of us we missed it on that last, isn't it?
Now pending the RFA.
Okay, there is something might be mind of that court, and there is a judicial order. We should not ignore it. That is the discipline.
No, in fact, when it was heard that day, may I just point out to your lordship?
It will likha next case to come. Item number
63. No. 64.
none appears for the petitioner. Call this matter is pending since 2015. The learned senior counsel for the senior counsel representing the Coal India Limited submits that the petitioner has already filed a civil suit. Civil suit seeking compensation for the alleged illegal.
They have already filed a for right title in
For the suit has already preferred a suit for right title of interest in respect of the land in question, be that as it may, and same has been dismissed. So be that as it may, as none appears for the petitioner on call, and this matter is pending since 2015. The same stands dismissed for non. It would pick up Mrs. Sharma, learned counsel for the state respondent, more particularly the circle officer, submits that he may be granted some time to file the affidavit in terms of the circle officer may be granted some time in terms of this court's order dated 18/1/2024. Prayer is allowed not before May.
Yes, Lord.
This circle officer, everybody will be busy in the festival of democracy.
Festival.
Isn't it? So place this matter in the month of June.
May I pray for that in that case?
Okay, give a date in the month.
June.
11 to
11. Oblige. List is complete.